Royal Commission is now in session. Please be seated.
Here we are for the fourth set of hearings. I'll just indicate that my plan for the moment is to stick to regular inquiry hours of 10 till 1, 2:30 till 4:30, until we start getting in trouble with the witness list, in which case we'll adapt accordingly. Yes, Mr Gregory.
Yes, thank you, Commissioner. This morning I appear with Mr Freeburn of Council. This afternoon I will appear with Ms Berry of Council.
Thank you. Yes, Ms Hogan-Doran.
Commissioner, I appear today with Mr Glover of Council for the Commonwealth.
Thank you. Mr Andreatidis.
Good morning. I appear instructed by King and Wood Mallisons for Mr Wann, who is number 5 on the list today. Commissioner, can I be...
not before time for...
Ms Lees and Ms Wann are unlikely to be reached before lunch, so not before 2:30.
Okay, you're confident about that?
Yes.
Can you leave a phone number just in case anything moves faster, to be on the safe side, but otherwise not before 2:30?
Of course, thank you. May I be excused?
Yes, thanks.
Thank you.
Yes, Mr Gregory.
Thank you, Commissioner. The fourth public hearing of the Royal Commission into the Robodebt scheme, of course, commences today for a period of 3 weeks, concluding on Friday, 10 March 2023. It is planned to be the final public hearing. The list of witnesses was published on the Commission's website and reflects the substantial body of oral evidence on a range of topics, which is anticipated will be given during this hearing. The broad overview of those topics was also updated on the website. Those topics reveal the Commission's continued interest into critical points in time where decisions to implement, continue and ultimately wind up the scheme were made. The evidence is expected to focus on who knew what and when about the 4-year budget measure, which came to be known as the Robodebt scheme. It will also focus on why critical information was not communicated to decision makers, or if it was, why it was not communicated outside of the relevant departments. The evidence is also anticipated to include why those in positions of seniority made decisions to implement or continue the scheme despite their knowledge of flaws and in the face of public scrutiny, independent investigations and legal challenges. Last week, the Attorney-General announced the extension of the due date for the delivery of the report of this Commission's inquiry into the matters set out in the terms of reference. The due date is now 30 June 2023. The extension reflects the significant work needed to address the terms of reference and the extraordinary volume of material produced in response to the various notices issued by the Commission. By way of example, during the last hearing block, which commenced only a month ago, over 100,000 additional documents were produced. That fact and the extension further illustrates what I said in my opening address, that much of the work of the Commission involves the analysis of documents and evidence which is undertaken outside of these public hearings. 2 documents were produced which have not previously been tendered. They are to be Exhibits 5106A and 5107. It's convenient at this point, Commissioner, if I tender the list of exhibits or tender the exhibits listed in the draft list for the whole day. It commences at 5106A and concludes at 5268.
Exhibits 5106A through to 5268 as listed in the exhibit list are admitted.
The 2 documents to which I just referred, which had not previously been tendered, are directly relevant to the question of the advice received by the Department of Human Services at a point during the scheme, and I call at this point for Exhibit 5106A to be placed on the screen. Commissioner, you may recall evidence that Ms Mussolino, as Chief Counsel of DHS, sent an email to all legal departments on 23 January 2017, and it is contained there in the bottom half of that page, and it sought identification and provision of legal advices, whether internal or external, provided by legal to the business regarding debt recovery of Centrelink overpayments. In response to that request by Ms Musolino to the various persons listed as recipients to that email, Mr Glyn Fiveash produced document 5107, and I'd ask that that be placed on the screen. And it was produced, as that first document indicated, on the same day. Mr Fiveash communicated to Ms Musolino that he wrote this, which he described as an information piece for the strategic analysis section a couple of weeks earlier. The language of the advice addresses the question of debts as is identified in the subtitle. And in the first paragraph, Mr Fiveash identifies two stages of assessment of entitlement. The first when a person receives an income support supplement, and the second in respect of the question of whether there had been an overpayment. In the second paragraph, which is of direct relevance to the inquiry, Mr Fiveash provides advice to the recipient about the question of whether averaging may be used, and he arrives at a position which is set out in the last 5 lines, where he concludes, that is, the department cannot apply an income amount received over a larger period, for example 12 months, in any way against a customer other than the manner in which the person received it in those individual fortnights. And the explanation is given there. He concludes, rather the annual amount needs to be apportioned between the relevant fortnights in the period at the rate at which it was actually earned, derived or received. The use of the word apportioned in the final sentence has been used in a different context throughout this inquiry, and the emphasis in the full context of the advice on the last sentence is the word actually. Mr Fiveash refers to the critical factual point about when income was earned, derived or received, rather than the concept of averaging, which is set out above. That, properly understood, was an advice that averaged income could not be used to calculate debts by the department. It is not clear what, or rather the evidence does not yet reveal what Ms Musolino did with that advice after receiving it on the 23rd of January 2017. And part of the oral evidence to be given during the course of this hearing, I expect, will involve questioning of Ms Musolino on that topic. The document can be taken down. Additional questions under the broad category of legal advice have been the subject of discussions between solicitors assisting the Commonwealth and solicitors assisting the Commission in recent months. They fall into 2 categories. The first is the question of whether the Commonwealth considers that it has waived or will waive legal professional privilege in respect of the advice from the Australian Government solicitor on constitutional risk for the purpose of the new policy proposal, which was considered by the Expenditure Review Committee on 25 March 2015. The Commonwealth position, I understand, and a letter will be produced to this effect, contends that it has not waived and will not waive privilege in the constitutional risk advice. The consequence of that position, and solicitors assisting the Commission are considering it, is that in that specific respect, this Commission will not be able to address the question of the nature of the advice received by the Commonwealth in respect of the budget measure. However, there are discussions in play which may reveal a portion of the advice without leading to the ultimate conclusion. That is a matter which the solicitors, as I said, continue to correspond on. The second category of legal advice, which has been the subject of a correspondence between the solicitors, is the Australian Government solicitor advice in respect of how persons who were prosecuted after having debts raised which involved the use of averaging ought be treated in respect of the categories of persons identified in the class action, or rather the classes of persons identified in the class action. The Commonwealth, I understand, is writing to solicitors assisting the Commission to inform them that similarly to the constitutional risk assessment advice, the Commonwealth maintains legal professional privilege in respect of the AGS advice about what I might describe as the fraud cohort. That question has had relevance to some witnesses, particularly Mr Carter from the DPP. The Commission might recall that I reserved tender of a category of documents, and there are witnesses tomorrow to whom that question is relevant, but in view of the volume of material today and the evolving situation, it's not relevant to seek a ruling in that respect at this point. It may be necessary to raise it again tomorrow upon receipt of correspondence. I simply flag it at this point, but again, in the event that the Commonwealth proceeds in the manner that it has foreshadowed to me and which I have just outlined, the Commission will not be in a position to address that category of the term of reference which deals with advice received by the Commonwealth in respect of the scheme and the response to legal challenges. If I turn then to the topic of submissions, the Commission has received more than 1,000 submissions from various people over the course of the Commission so far. Those submissions fall into two broad categories. Those who experience the Robodebt scheme either personally, including those who worked at Centrelink, DHS or DSS, or through family members, or who have direct personal experience which they have shared with others. And secondly, those whose qualifications, work experience or profession allows them to make submissions which assist the Commission to identify flaws in the scheme, reasons why existing checks and balances were unable to halt the scheme, and recommendations to avoid the repetition of what may appear on the evidence so far, and without any concluded view, of course, of the apparently systemic issues involved in establishing and maintaining the scheme. I anticipate that the submissions falling into the second category, broadly described as expert submissions, will be able to be tendered later this week. The Commission has also engaged 3 persons who fall into that category of experts to produce reports which will assist the Commission. Dr Aaliyah Worth, who is listed on the witness list for the 3rd week of this hearing block, and Deloitte have been engaged to provide expert advice on the design and implementation of the scheme. That advice will be provided by way of detailed process maps of the way that data was transmitted between DHS and the ATO, and the way the data was used at DHS to raise debts during the period of the scheme, and a report to the Royal Commission. The report will address the following questions: the technical end-to-end scheme process as it pertains to the automation of employment PAYG compliance program delivered across DHS and the ATO, including population identification, identity matching, income matching, debt calculation and debt notification. I pause there. A number of the expert submissions received in the broad category that I identified earlier include submissions in respect of automated decision-making and the use of artificial intelligence in decision-making. The report will also address whether the activities undertaken by DHS appear to differ from the requirements outlined in the agency's framework documents, what governance, controls and risk management instruments were in place between and within DHS and ATO to ensure that PAYG income compliance program was compliant with their own framework documents, whether the governance controls, risk management instruments identified were sufficient, to what extent and in what steps the PAYG income compliance program was automated, and what steps could be taken in future data matching programs to improve two features. First, governance, risk management and controls for income data matching to improve compliance with legislative instruments and protocols. And second, trustworthy automation to improve compliance in the same way and adherence to the values of the Australian Public Service. Ms Worth has been briefed with hundreds of primary documents produced to the Commission for the purpose of this engagement. I can indicate that the ATO and Services Australia were provided with the process maps last week, and we are awaiting their response in that respect. It appears from the information provided to the Commission to date that Ms Worth's analysis of the end-to-end program is the first of its type, despite the systems being established in 2015 and 2016. The second expert engaged by the Commission is Professor Whiteford. He has been engaged to provide a report in relation to patterns of employment and earnings of income support recipients at the time of the introduction and application of the Robodebt scheme, including a review of data and analysis being produced to the Commission by the Department of Social Services. The Commission may recall the observations of Justice Murphy in the reasons for the settlement of the class action, which referred to what ought reasonably be expected to be known by the departments about those who were in receipt of those benefits. His report will address a number of critical features, whether the use of data based on the assumption that a recipient's income can be averaged over an annual period to identify overpayments is consistent with policy directions in the social security system with respect to encouraging work by benefit recipients, changes in the employment patterns and income patterns of income support recipients in the period 2010 to 2015 prior to the introduction of the scheme, and in 2015 to 2019 during the scheme. Patterns of interaction of income support recipients with the social security system in the period 2010 to 2019, the nature of the labour market and work opportunities for low-income earners and income support recipients in that same period, and in light of those characteristics, whether the assumptions underlying income averaging, that is, that incomes are consistently earned with little variation between fortnights, could be regarded as reasonably accurate or as reasonably reliable indicators of fortnightly income, and whether any concerns identified in relation to income averaging would or should have been identifiable in 2015 based on the information available at that time about the employment and income patterns of recipients. The third expert is Mr Podger, a former Public Service Commissioner, to provide a report which addresses certain questions which arise for consideration from the terms of reference and evidence to date. His report will address the role of the Australian Public Service and the professional relationship that exists or existed between public service leaders and their agency ministers and their respective responsibilities, the responsibilities of individual public servants, particularly secretaries of department and those in the senior executive service and executive level, including their statutory obligations under the Public Service Act 1999 and the Public Governance, Performance and Accountability Act 2013 and the Public Interest Disclosure Act of 2010. For the relevant period of the scheme, the relationship between the policy advising and administration, as well as the structure of the social security portfolio, that is, the respective roles of and relationships between the Department of Social Security, Social Services and Services Australia, the annual budget process and mid-year economic forecast process arrangements for ensuring Cabinet had sufficient information, including on legal and other risks, to make proper decisions, the relationship and level of engagement between Services Australia and DSS and each agency's clients and stakeholders, the use of technology in the administration of social security payments, including data matching and automated decision-making, the role of compliance and the appropriate balance between compliance and the proper administration of beneficial legislation, particularly the social security laws, the level of APS capabilities within the social security portfolio, including with regard to policy advice, administrative experience, understanding of social security and administrative law and project management, the question of the culture of Services Australia and DSS and the levels of communication between the two agencies, the quality of record keeping within the Australian Public Service as it has been identified in this Commission, and his recommendations to address any concerns which he identifies which appear to him to be systemic, and any concerns identified in respect of critical points in the scheme. Each of these reports are being finalised, and I expect that they will be tendered later this week. I turn then to the question of evidence today. Commissioner, the evidence today will commence with Ms Miller, whose son Reece Corso committed suicide on 26 January 2017 after deaths were generated using averaging in the PAYG manual compliance intervention process during the 2015-2016 financial year. After the morning break, I expect, of course, Ms Miller will take us to that point. Ms Prygodicz and Ms Button will give evidence as a panel of their personal experience with the scheme and their conjoint experience as lead applicants in the class action. And this afternoon, as I indicated earlier, Ms Lees, the former Chief of Staff to Senator Payne in 2015, and Mr Wann, former Chief of Staff to Mr Morrison in 2015, will give evidence of their role insofar as it is relevant to the implementation of the scheme and their respective ministers' knowledge of the development of the scheme and attendance at the Expenditure Review Committee on 25 March 2015 when the measure was approved. It is convenient then if Ms Miller be called.
Yes. Ms Miller. Now, having got you sat down, I'm going to ask you to stand up again. Would you rather take an oath or an affirmation?
Affirmation, thank you.
All right, we'll get that administered. Thank you.
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thanks, Ms Miller. Yes, Mr Gregory.
Yes, for the record, I can indicate that Ms Miller is supported by her partner, who is present, and is also represented, and her representative is present in the Commission room, should the situation arise. Ms Miller, can you tell the Commission your full name, please?
Jennifer Joy Miller. Can you hear it?
Well, I can, but do you think there's a...
I can't see a microphone, as is usually the case, but all right.
Ms Hogan-Doran, you always notice if there's a problem. Can you hear Ms Miller all right?
I think the problem is that my microphone was on, it's now off, and hopefully that improves everything. I think my microphone was on, which may have been picking up ambience in that.
Yes, okay, right, all right. So let's try again.
Ms Miller, you have provided a statement dated 17 February 2023 to this Commission,
Yes.
and it sets out in some detail what you now know as a result of viewing various documents produced to the Commission which have been tendered earlier today.
Yes.
And your knowledge relates to your son, Reece Corso,
Yes.
and your involvement in communications with various government entities, both state and Commonwealth, over the last 5 years.
Yeah. Six years. Yeah.
Yes, thank you. You are the mother of 2 boys, Ms Miller,
Yes.
and Reece was the younger of those 2.
Yes.
He passed away on the 26th of January 2017.
Yes, that's right.
How did you come to know or learn of that?
The police arrived to our house at 3 o'clock in the morning and delivered the news that Rees had passed. The reason that they came to the property was because of social media. They were worried that maybe I would have seen something on social media about it before I knew about anything, so yeah.
At the time, you were living in Queensland,
Yes,
and you still do.
yes.
And prior to his death, where did Rees live?
Rees was living in Cairns, but he was living in Melbourne from 2009.
And he'd lived in Melbourne from 2009 through to January 2017.
Yes, yep.
You came to learn that Rees received letters alleging debts in late 2016.
Yes,
And if we jump forward a number of years to 2020 and 2021, did you come to learn that monies recovered from Rees by the Department of Human Services prior to his death were refunded to him?
yes, that's right.
And the debts that were alleged against him in late 2016 and continuing in January 2017 were zeroed, to use the term, which is...
Yes, that's right.
Thank you. When you learned of your son's death, what did you do?
The first 24 hours was fairly hazy, but I immediately had a plane booked to fly down to Melbourne, as I obviously needed to make arrangements, and I went to the property where he was living, and which was the next afternoon, and I was frantically searching for him, leaving a note or something, some explanation, and because it didn't feel right, I just knew it wasn't just like a simple reason, I suppose. So whilst I was going through all the property, I also collated any material that may be necessary for me to follow up on. And then on the fridge, I found the debt letters from Dun and Bradstreet and a picture of Rees with a gun to his head. So when I saw that, I knew that something wasn't right.
You say Dun and Bradstreet. Did you come to learn that a debt collection agency, Dun and Bradstreet, had been assigned by the Department of Human Services to pursue Rees in respect of the debts alleged by the department?
Yes, yes.
And do you recall how many of those letters were on the fridge?
There was 5 letters, and I thought it was like a business card that had been left there, but it was like a sticky note that had been left. Easy peel, I think they call it. Yep.
And was it your understanding at that time that this note was something left by the debt collector,
Yes.
Bradstreet,
Yes.
asking Rees to contact them?
Yes.
And had been delivered to the house at some point?
Yes.
Before I move on to the other document that you found, was Rees living alone at the time?
He was living with his partner.
Yes.
And also a friend. And they had been out all day, and Brett had gone out to go and get some cheesecake, and she came back and found Rees.
Now, the drawing that you found, what type of drawing was it?
It was a face with a gun through there and dollar signs just coming out of his head.
Right.
And it had debt life written on it, I think.
When had you last seen Rees?
I had been down in the first week of June. Towards the end of May, Rees had rung me and he was really, really quite distressed. And so I said to him, I'll come down, let's, sort some things out. He said, I've got a debt letter. I can't be right. And so I flew down in the June, and I spent some time with Reese to get him back on track and thinking clearly and helping him. Unbeknownst to me, he didn't actually let me know how much pressure he was starting to feel from the debts, and plus we didn't know anything about Robodebt. So it was like, no, this can't be real. So yeah.
And do you recall the amounts of the debts that you and Reese talked about when you visited him in mid-2016?
The first debt letters that I saw was for around $10,300. And then the next one included an extra debt, but I thought was a separate debt, and that was 17,000 something.
And did you later come to learn that the 17,000 odd figure was a combination of two alleged debts?
Yes.
You say Reese hadn't discussed the full extent of the impact of the debts on him when you spoke to him in, I think it was May 2016?
Yes, end of May.
End of May. And that is when you visited him in Melbourne?
Yeah.
But had he indicated to you that there was some effect upon him in respect
Yes.
of the debts?
Yes.
And is that what prompted you to go and visit him?
I would go down and see Reese as often as I could, and but yeah, he was very distraught when he made that phone call to me, and he said he was feeling suicidal, and so we probably spoke for about 2 hours on the phone, maybe longer, and I said, okay, I'm going to come down, let's set up a program for you to go back to the doctor, back to the psychologist, and let's get you, under review so that I could manage him and he could manage himself, yeah.
Okay. How long did you stay with Reese and his partner?
It was for about 5 days.
Okay. The indication of what you've just said is that Reese did have pre-existing mental ill health.
Yes.
Before we come to that in detail, you said that he was in Cairns for a period. The family lived in Cairns. Is that where he went to school?
Yes.
What can you tell the Commission about his last few years of school?
We started seeing some signs of him having anxiety and so forth, but, to be honest, we probably didn't really think that there was something going on mentally. But he had a great group of friends. He was doing okay at school if he set his mind to it.
Like most boys?
Yes. Yep. He finished year 12. He was very creative, and all his mates, they had their own band. They do skits. They had a good time. Yeah.
And when it came to the decision to leave Cairns and go to Melbourne, how did that come about?
The boys all decided that they wanted to have the music vibe and the artistic vibe that happens here in Melbourne, and yeah, so they got very involved in playing music at different pubs and what have you. Reese would do the artwork for many of the bands, for their posters, and yeah, very creative.
What did you learn of his employment once he moved to Melbourne after finishing grade 12?
Look, initially, all the boys were probably couch surfing and doing whatever. And ultimately, they did all settle down and find places to rent or share with. And Reese did spend a bit of time with my husband's family down in Melbourne as well. And but he did work. He worked always on a casual basis, and he was working for Museum Victoria as a photographer, and then he was working as a florist for quite a number of years.
You indicated earlier that he was artistic, and that obviously extended to photography.
Yes,
Was that a long-standing interest?
yes, yes. He had commenced casual work when in Cairns, and that was after school and weekends. Yeah.
So he had at least 2 employers at various times?
He would have had, in his time in Victoria,
Yes.
I think there was 3 or 4. Yep.
And you said you understood that it was always casual work?
Yes, yes.
Okay. Did you talk to him about his finances periodically and how he was going?
Yep. Yep. And if he did need assistance, we'd all help him out, you know, like, I can't pay my rego this week. Okay, I'll pay it for you. But he wasn't, both boys weren't like relying on us for finance. It's just that sometimes they, you know, are boys.
Following Reese passing, you were involved in the funeral arrangements,
Yep.
and did you come to meet his employer at the florist?
Yes, yes.
What did they tell you about Reese as a worker?
They adored Reese. He was highly respected by everyone he worked with. And they were shocked, as we all were, but he was reliable. They could always count on him to be there at work when he was required. And to the point that with his funeral, Vizette set up the most beautiful display on behalf of Reese. And all his previous employers and those from Vizette, they all attended his funeral.
Did you have, or do you recall your first engagement with the Department of Human Services or Centrelink after Reese's passing?
After the funeral, so I had stayed in Melbourne for a good month. So after the funeral, I rang Centrelink, that would have been the 13th of February, and to advise them of Reese's passing. I was on hold for 57 minutes and then I was told, well, I can't input the information, the computers are down or something. And of course I wasn't feeling really favourable towards anyone at Centrelink or anywhere else. And yeah, so that was a bit of that stirred me up quite a bit because I certainly didn't get really any response from them. And I asked them if they could advise Dun & Bradstreet, and they said, no, you've got to do that yourself.
So following that telephone call with Centrelink, you telephoned Dun & Bradstreet?
Yes.
And informed them that Reese had passed?
Yes.
Have you had the opportunity to listen to a recording of your phone call?
I probably wouldn't like to listen to a recording of that phone call.
You recall it was very distressing?
Yes.
The first that you became aware of Rees's debts, as you've said, was in May 2016?
Yes, for the initials, yep.
At the initial stage, yes. And one of the documents that you have referred to is Exhibit 5186. It's a Facebook post of Rees. You recall that?
Yes.
I'll ask if that can be put onto the screen, please. And this is the particular post that we can see, May 25, 2016. Any social service people around? Can you see that?
Oh, yes, yes,
Yes.
yes.
That's a post by Rees where he says, got a huge debt notice from Centrelink, which I believe is incorrect, but not too sure how to go against it since my proof, brackets, pay documents, etc., are long gone from 5+ years ago. Help. See that?
Yes.
Thank you if that could be taken down. Did he express a similar sentiment to you when you visited him later that month?
Yes, yes.
And did you understand that he had been asked to provide pay slips from many years earlier?
I didn't realise it was going back that far, and it's only through the documents I've seen now that they had raised certain debts over certain years. So when, because like I said, we didn't know anything about Robodebt, and it really wasn't until after he had passed that I started hearing about it, talking to his friends and his boss at Vizet. Yep.
Okay. Well, you notified Centrelink and then the debt collector, Dun & Bradstreet. What steps did you take after that to find out what had happened in respect of these debts?
I sent letters. So I sent letters to Tudge, to the Ombudsman. I also requested an inquest for Rees's death.
That was with the coroner for the state of Victoria?
Yep.
Or the office of the coroner?
Yep.
Yes.
I had gone to the Saturday paper as a lady who owns Vizet is a friend of the owner of the Saturday paper, and we had started discussing depression and debt and what have you, and so she spoke to the owner of the Saturday paper, and Martin McKenzie rang me.
He was a journalist?
Yes, yes.
All right. And you were interviewed by the journalist?
Yes.
Over a number of hours?
Yes.
And later a story was published?
Yes, it was.
In February 2017, I think?
Yep. And it was the front page of the Saturday paper.
All right. What were your motivations for wanting to speak to a journalist about what Rees had gone through?
I just didn't want anyone else to suffer. And in that article I said, please reach out, please, if you get any debts like this, please reach out, please ask questions, because don't take your life over a debt. It's not worth it. Yep.
The attempts that you made to obtain information from various people, how successful were you, broadly speaking?
I had absolutely no success whatsoever
Over what period of time?
over the 6 years.
What information or what were you told about why information about Reese couldn't be released to you from the department and elsewhere?
I was given numerous excuses. So I'd written to the Ombudsman as well and asked them to question the debt received. I did only receive, I suppose, platitudes from them, from Tudge's office, from, oh my God, I wrote to every MP, and yeah, Senate inquiries, just everything. And not once did I get a truthful answer, not once.
I said I would come back to Reese's pre-existing mental health.
Yep.
Is it the case that it's only in the course of reviewing documents which have been tendered this morning in preparation for your statement that you've been able to understand the circumstances in which the alleged debts were raised?
Yes.
You've also found out some other information about Reese and his interactions with Centrelink.
Yes.
I ask that Exhibit 5113 be placed on the screen. And you may recognise this as one of the many documents held by Centrelink about Reese, Ms Miller. And if I could take you to page .8814. About 20 pages in. Ms Miller, this is a document called the Job Capacity Assessment Report
Yes.
for your son, and this is one of the documents which you came to learn of only in recent weeks.
Yes.
It indicates that Reese was applying for a job capacity assessment, and you can see the referral details there include the reason for assessment, a DSP new claim, which you understand to be a disability support pension
Yes.
new claim.
Yes.
Right. And if we go to the bottom of the page and over to the top of the next page, under the heading medical conditions. Yes, thank you. What is described here is the condition described as a psychological or psychiatric disorder
Yep.
of a permanent type, and which has been verified by medical evidence as fully diagnosed, fully treated, fully stabilised. And it refers to a report by a doctor in August 2015 which notes anxiety and depression. You see that?
Yes. Yes.
What's also indicated there is the onset date of 2008. Do you see that?
Yes. Yep.
Now, Reese was still living with you in Cairns at that point,
Yes.
and you said earlier that you noticed some symptoms of anxiety in him in his
Yes.
later high school years.
Yep.
Does that sequence sit generally with your knowledge of your son?
I think onset was prior to that,
Right.
that I would have noticed, but I do believe that he did have a indicator on his file because I had papers from 2010, 2011 when I was a nominee. But that's very consistent with.
Yes.
Yeah.
You referred to being a nominee.
Yep.
Can you just explain what that means?
Before Reese moved to Melbourne, he asked me if I would be a nominee for him so that Centrelink could send me whatever he got sent, so I'd get a copy of that. and so I could always keep a note on what he was up to.
Right. And did that notification of being a nominee allow you to independently, as it were, have access to Reese's information
Yes.
in respect of Centrelink?
Yes.
That nomination stopped at some point?
That concluded, I think it was around early 2011, because Reese decided that he didn't need his mother to be a nominee anymore.
The symptoms which are described here include anxiety and panic attacks and various reports,
Yes.
which include rumination, isolation, withdrawal, suicide ideation, but without any plan or intent. And that appears to be an assessment as at September 2015.
Yes, yes.
You said that you were aware of some notifications on Reese's file, that is his Centrelink file from around 2010 or 2011.
Yep.
What do you recall of that?
Because of his depression and mental health, I was very certain that there was a vulnerability indicator on his file, and so I would have expected that to still be on his file, but it wasn't after that period.
And why was the presence or otherwise of a vulnerability indicator significant to you?
It flagged that this person does suffer from something, and that generally maybe a social worker or someone would be in contact if he had any difficulties with anything to do with, inputting data or putting in his wages or, That didn't happen.
If I could have Exhibit 5154 placed on the screen. Ms Miller, this is your letter to then Minister Tudge, the Minister for Human Services. Sorry, his response to you. You described it earlier as a platitude. What do you mean by that in the context of what he wrote to you?
There was absolutely no genuine effort of trying to give me any information. As far as I'm concerned, they were just false words.
We're just locating your letter to him, but did the concept of a vulnerability indicator feature in your letter to him?
Yes, yes.
And what do you recall of how you referred to it?
Obviously, by this stage, I had been investing a lot of time into looking into the Robodebt, and I do recall when himself and Katherine Campbell were on the news or whatever, that if there was a vulnerable indicator on their file, that they would make sure that these persons are not issued certain debt letters and not referred to debt collectors, and that they look after that person. So when they kept saying to me, well, we did this manually, and my answer to that was, okay, well, if you did it manually, then that's even worse. You should have seen he had an indicator on his file.
And that's because you believed, well, you knew of the indicator in about 2010, 2011?
Yes, yes.
And you believed that it would still be present on his file
Oh, yes.
in 2016
Yes.
when the debts were raised. Did you come to learn that it had not been maintained as a current indicator?
I've come to learn that now, yes.
Right. We'll just bring up your letter. It's Exhibit 5177. That's the letter you sent on the 3rd of March 2017 to the Minister.
Yes.
Right. And the reference that you make to the question of vulnerability is at the bottom of the page. You can see it commences, it was also very well known to Centrelink and his job search providers that he had these issues
Yes.
with referrals, reports from doctors issued to them.
Yes.
And that you are referring there to what you understood to be the case in 2011
Yes.
or thereabouts. And then you refer to what Mr Tudge said on television, I think you said, at the bottom of the page and over to the top of the next page.
Yes.
Where it was said by the Minister publicly, if someone is known to be vulnerable and this is reflected on their file, they won't receive Centrelink debt notices.
That's right.
And you go on to explain how that could not have been the case because it was known to Centrelink and he still received a debt notice.
Yes.
As you indicated earlier, it's only very recently that you came to learn of the job capacity assessment report, which related to Reese's application for the disability support pension
Yes.
in September 2015. Before we come to that, we can go back to the response from Mr Tudge, but did he address this point at all to you?
I don't remember.
All right.
I can't recall.
Thank you. If we go down to the middle paragraph commencing while the review identified,
Yes. That's it.
do you recall now that that was the extent of the acknowledgement of some minor errors of an administrative nature?
Yes.
Okay. If I could have Exhibit 5143 brought up, please. Ms Miller, this is also a document that you've had access to only recently,
Yes.
and it is the first information that you have become aware of from the department about the question of the removal of the vulnerability indicator on
Yes.
Reese's file.
Yes.
And you've seen that various people are involved in this lengthy email trail, and this is all on the 15th of February 2017, at about the time that you were interviewed by the journalist from the Saturday paper.
Yes. Yes.
And that's the context in which it appears this email was generated within various people within the department.
Yes.
And if we go to the email at the bottom of the page from Ms Bacuzzi, over to the top of the next page. The record, that is the internal record within the department, revealed this position, which was communicated, that a psychiatric problem or mental illness, brackets PPM vulnerability indicator, is a flag added to a customer's record when it has been identified that this vulnerability could potentially impact their capacity to comply with job-seeking requirements or put them at a higher risk of non-compliance.
Yes.
And the PPM vulnerability indicator was coded for Rees on 5 June 2010, as you recalled.
Yes.
But it can be fixed according to this email for only 52 weeks and then be reviewed on a review date, which is specified by the indicator.
Yes. Yep.
That is, you came to understand that the indicator existed on Rees's file for a year.
Yes. Yep.
And then as the last 3 dot points indicate, that it also auto ends 2 weeks after the scheduled review date if it hasn't been reviewed. That is within DHS or Centrelink.
Yes. Yep.
And that in this case, it appears no review was conducted within that 2-week review period after the 52 weeks, and so it lapsed or was taken off automatically.
That's right. Yep.
We go to the top of the page then, and you refer to this in your statement, Ms Miller, commencing, "Hi Carla, thank you for your email." That you understood after reading this, I take it, Ms Miller, that really those within the department hazard a guess about why it was no longer there.
Exactly. Yep.
And the explanation was that there was no documentation during the review period, and that might be the explanation about why it wasn't renewed for a further year. Okay. And it is noted that they could try and escalate to assessment services, however it is 5 to 6 years ago, ...
Yes.
Right. Is this document, I think as you indicated, the first information that you've been given about the removal of the vulnerability indicator?
Yes. Yes.
You've now received also the job capacity assessment that I took you to earlier.
Yes.
And it's clear from your review of the documents that even though Rees applied for the disability support pension in respect of long-standing mental health conditions, which were currently diagnosed,
Yes.
no vulnerability indicator was placed on his file.
No. No.
Would it be fair to say, Ms Miller, that once you read this document, you had a high degree of frustration with the response of the Minister who didn't address your question about vulnerability indicators in May 2017?
Very much so. And as he said in his letter, there was some, minor administrative faults. Well, I see that as a major fault.
We could turn then to your statement. You have, in your review of the documents tendered today, prepared a chronology which sets out Rees's interactions with the department
Yes.
over a number of years.
Yep. Yep.
And particularly you set out the history of interactions in respect of the alleged debts. If I can take you to your statement, and if it could be brought up on the screen, commencing at paragraph 23, did You set out there, from paragraph 23 onwards, really the start of the chronology as you came to understand it very recently
Yes,
about those interactions.
yes.
What can you say about Rees's response over time to those interactions? Did he continue to respond? Did it drop off? What can you say?
From accessing the documents and information that I have been able to now, I do now know that he received a phone call about his pay-as-you-go for, I didn't realise what year, but went back to the first debt, saying, this is what you earned in this year, do you agree with that? And Rees had said yes. Nothing was explained at all. And then he started receiving letters from Centrelink saying he had a debt. And looking at the amount of harassment, Rees would either not have answered the phone or he may have been working, but he would have avoided having to talk to them.
In paragraph 21, you refer to the person that Rees was living with, and you spoke to her about her knowledge of the letters that he was receiving.
Yes,
And what she told you is set out there, that she was shielding him from the letters as they arrived.
yes, that's right.
Okay. And what you came to learn after his death in 2017 was that after receiving the first debt letter in May 2016, there was an attempt.
Yes.
All right. He didn't share that with you when you visited, apart from the fact that he was generally distressed.
Yep.
And
He did not. He did not tell me about his first attempt, and as it was winter, and of course he had coats and whatever on, I certainly didn't notice. But yes, he tried to slice his throat. Yeah.
even though he didn't share with you to that extent, you understood that he was distressed and attended and
Yes.
stayed for 5 days.
Yes.
You put in place various precautions or measures to assist him to deal with the alleged debts.
Yep. Yep.
And what were they?
Whilst I was down there, we went to the Centrelink office, and because I said to Reese, something's not right. Surely they can look at your file and they'll be able to tell you. So we went to the Centrelink office and they said, no, we can't help you. And they pointed out a 1-800 number on the wall. And we went back to his property and I said, no, this is a joke, Reese. Don't worry about it. Let's get you back on track. I'll deal with this later on. But I was worried about him as a whole because he was just so stressed. So organised the doctors, organised the psychologist again, and got him back on track, as in thinking clearer. And he was to text me every day to say that he was okay. Yep.
And those measures were applied?
They were applied, and I thought we did have it quite well managed. And as it got later on into the year, my other son, he was not in a good way, and at the time Reese was talking to his brother daily, and he didn't express to either Josh or myself that he was being harassed like he was.
Right. We turn over to paragraph 34 and 35 on page 6. You identify from what you now know is that on the 12th of August 2016, Rees attended a general practitioner and a mental health care plan was developed.
Yes.
He was referred for some psychological treatment. But within a week, he stopped receiving his New Start payment as he hadn't reported his
Yes.
income.
Yes.
Did you as a mother see a relationship between the decline in his mental health and his ability to relate or respond to Centrelink?
Oh, definitely.
And did you also then appreciate from your recent review of these documents the compounding effect of not receiving the support, the income support that he was entitled to at that time because he wasn't engaging with Centrelink?
That's right. Yep.
Over on paragraphs, page 7, really paragraphs 43 through to 54, you set out there the various contact from Centrelink towards Rees and contact from Dun & Bradstreet, the debt collector.
Yes.
And you've been able to identify each of these occurrences from the information produced to the Commission.
Yes.
Which
Yes.
was tendered today. Yes. And if we go to page 8, the chronology continues there with relatively repetitive contact through into early January 2017.
Yes. Yes.
And as you summarise at paragraphs 68 and 69, he received 12 letters from Centrelink between May 16 and 20 October 16. He was phoned between 5 and 6 times. And after the debt was referred to Dun & Bradstreet, he received 6 letters, 2 text messages and 13 phone calls between 7 November 2016 and 6 January 2017.
Yes. Yep.
Can I ask that Exhibit 5147 be produced and placed on the screen? Thank you. This is an email, Ms Miller, an internal email which forms part of the material tendered today to which you've had access. And this contains the exchange between the journalist and the department, and then internally between people in the department.
Yes. Yes.
And the email commences at page 3810, good afternoon Martin, on Saturday, February 18 at 3:33 p.m. You can see that?
Yes.
And this was the department's request that the journalists publish a corrected story, as the department did not think it accurately represented the department's processes. See that?
Yes.
Now, were you aware from the journalist at the time that there was this contact going on?
No. No.
Right.
But he did inform me later on when Rees's private information was sent out to the media.
And the information which related to Rees is contained on the next page of this email, 3811, and over to 3812, where the department provided a very extensive account of the response to the story which had been published that day.
Yes. Yes.
And a good deal of that information had not been provided earlier to the journalist when he sought comment from the department.
Yep.
All right. That is, you're able to say that from your review of the documents.
Yes.
And the journalist's response, if we can go back to the first page of the document, .3809, after receiving that information and request from the department at 3:39 or 3:33 in the afternoon. The journalist responded and asked some further questions, which he said arose out of that information. One was about the discrepancy between the $10,000
Yes.
and $17,000 figure, which you thought was the same debt or a separate debt at the
I
time.
thought they were two separate debts.
Right. And that in the last paragraph he raised the question, now knowing that Rees's debt was raised manually because of a pre-existing mental health condition known to Centrelink, in cases such as this, debt collectors are not used. Obviously, in this case, debt collectors were used and added to Rees's anguish. Could you explain why this happened at odds with what I understand to be departmental protocol?
Yep.
And the response from the department further up was, we have discussed this with the Office of the Minister for Human Services and advised that we have nothing further to add.
Yes.
That type of response, when you read that, did it seem familiar to you?
It was very consistent with the responses I've received all the time, consistently.
And you now know, if we turn to Exhibit 5148, that the departmental response on Saturday 18 February 2017 included emails from the media section to Mr Hank Yongan, which included that email at the top of the page, you see.
Yep.
And you became aware recently when you saw this document that the request to correct the record had been worked through today and cleared by Melissa, and the MO and the Secretary is also aware. You saw that?
Yes.
Mr Gregory, am I right in thinking that the only reason it wasn't an online compliance intervention is that he was part of the pilot and they hadn't got onto OCR at the stage the original debts were raised against him?
Yes, that's correct.
So it wasn't compassion, it was just that they hadn't got to unleashing the full scheme yet?
That's correct. Did you become aware of freedom of information requests for Rees's Centrelink file?
I actually only became fully aware of the way to go about it through Not My Debt.
That's the online website where you saw many
Yes.
stories about people who had experiences similar
Yes.
to Rees's.
Yep. And they had a pro forma document, and because even though I had written letters, I hadn't done the formal process of the form.
Your initial letters sought information about how Rees's debt was calculated,
Yes.
and you were not told that it involved averaging.
No, not at all.
When did you first come to learn about the concept of averaging?
Probably I started to realise that they were using averaging probably about 12 months after, but I still did not understand the concept. And it wasn't until people like Not My Debt were talking about the averaging and how it works, and I'm thinking, no, this can't be, that's not how they've done it. I just didn't believe anything that I was told, really. They kept just saying it was manual, and yeah. But it wasn't.
If I ask for, well, before I move on from that, Before you became aware of this email, which refers to Mr Yongan,
Yes,
you had previous experience with Mr Yongan in an indirect way.
yes.
Can you describe that to the Commission?
I attended the Robodebt court.
Referring to the class action?
Yes, sorry. To the
That's
class-
okay. It was a court and it dealt with Robodebt.
Class action. And I had submitted all my paperwork that I had, and I had been advised by Gordon Legal that Reese was in Category 1 and Category 2. And so when I appeared and Justice Murphy was asking me a number of questions and asked whether I had actually been told whether the debt was real, whether the debt was done manually or was it done through the OCI. And I remember clearly saying to him, I've never had that courtesy. No one's ever told me anything. And I do know that he was quite scathing about how I had been treated at the time. But as far as the class action was concerned, it was a little different than what I was looking at achieving. And so I think it was about 5 o'clock in the afternoon, I received a phone call from Centrelink social worker saying, now what can we do for you? In the meantime, Hank Yongan had done a press release with The Guardian and saying that he had been in contact with me on numerous occasions and spoken to me on numerous occasions. I never spoke to him once, not ever.
And so you wrote an email
I did,
where you expressed that you had never been contacted,
yes.
and it was directed to Mr Yongan.
It was, and also to the fact that this Centrelink social worker who was saying that they're going to help me achieve what I needed. So there was a number of phone calls back and forth. And because of where we live, I always made a time for them to ring because we are often out of service. And there was one afternoon and he was meant to ring me at 3 o'clock in the afternoon and I didn't receive the phone call and I thought, okay, well, I'll give him the benefit of the doubt, maybe he's a bit busy. So I never received a phone call back. So I then sent an email to Hank Yongan to let him know that I was still waiting on information and that I'm still waiting. It's been 2 weeks. I'm still sitting here waiting for this phone call. So, yeah.
If we could have Exhibit 5174 brought up on the screen. This is an email by you, Ms Miller, dated 27 May 2021.
Yep.
That's the email to Mr Yongan that you wrote after becoming aware of an announcement in the media that there had been contact
Yes.
on a number of occasions. And in the second paragraph, you refer to the court hearing. That's the one where Justice Murphy spoke to you and you spoke
Yes, yes.
about the fact that Reese had been notified as being part of, or potentially part of, the class action.
Yes.
And you refer to the statement in the press made by Mr Yongan that you had been contacted on a number of occasions and state your experience of that.
So there was quite a number of phone calls
Yes.
after the court hearing. And of course, I never got anything out of that.
In those phone calls, you, without going to the document, you recall that you've now seen a record of the notes made by the social worker who telephoned you after the court appearance?
Yes, yes,
And on the dates that you specify there?
yes,
And do you recall that in the course of those exchanges you kept asking for information about how Reese's debt was calculated?
yes, yes,
And you were told that the department would have to see what it could do because FOI requests take some time?
yes,
They said other things as well, but you understood that to be the gist of it?
yes. And I do recall them saying, the counsellor at the time saying, what you need has to be approved from further up.
Yes. I just had the transcript of your appearance in court, and I'll just turn that up. Exhibit 5165. Thank you. And if we could turn to pages 4022 and 4023. And the highlighted passage which continues is the transcript of your exchange with the judge.
Yes, yes,
You can see on page 4023 at line 37, His Honour asks, do you know whether your son's debt was generated by the use of income averaging from ATO data? And you go on to give your explanation that has not been given to you. That information has not been given to you?
no, that's right.
All right. And if we go to the next page, thank you. Do you recall that the judge started asking other people present in the court whether they were able to answer that question and give you that information?
I do recall that, but nothing was really forthcoming.
No one was able to tell the judge whether
No.
that was the case.
No.
And there was a question raised about whether they were able to tell you because of potential privacy concerns.
Yes.
Right. If I could have exhibit 5815 placed on the screen. You refer to writing to the Ombudsman in 2017 and then to the Office of the Australian Information Commissioner,
Yes.
also in the same year about the release of your son's information.
Yes.
And without going to the documents, is it fair to say that those bodies did not assist you to obtain information?
They did not assist.
Or rather, the response did not assist your understanding of...
No. Again, they were always just platitudes.
And you've included those, the correspondence with the Ombudsman
Yes.
and the Information Commissioner
Yes.
in your bundle. Returning then to the request for an inquest, this is page 1 of a document which you lodged with the Office of the Coroner in Victoria,
Yes.
seeking an inquest, and the reasons for your application were that at that time you suspected the Robodebt scheme was involved in the debts which had been alleged against him.
Yes, that's right.
But more particularly, that they largely contributed to his suicide, and that's what you were asking to be investigated further. If we go over to page .0017_0002, it's the third page, or recorded as page 2 of 2. Again, you set out some further reasons there in respect of your request.
Yes.
And it's clear at this point from what you said that you hadn't been provided with any information that allowed you to figure out to your own satisfaction, the relationship between the scheme and his death.
Yeah. I just had to keep plugging away.
You've now seen correspondence from Centrelink, that is internal correspondence in respect of the department's response to requests for information from the coroner.
Yes, yes.
We're just locating that. Exhibit 5159. You can see, or you now know, what is contained within this email from Ms Musolino to other people in respect of the Victorian Coroner's Court's requests.
Yes.
The introductory sentence notes that the Coroner's Court recently advised that it intended to reactivate its review into Reese's death, which had fallen into abeyance as a result of delays and backlog in the court. And there was the opportunity for the department to provide documents which might assist in respect of your request for a coroner's inquest.
Yes, yes.
At the bottom of the page, the request from the Coroner's Court is described, and over to the next page. And the first category identified at item 1 was material from the Centrelink file in relation to Mr Corso relevant to the raising and recovery of debt, including any communications or notes of communications between Centrelink and Mr Corso or any other person about the debt. You can see that?
Yes, yep.
From what you understood at this point in time, did you understand that information relevant to the decision to raise a debt for a person with the question of a vulnerability indicator was relevant to your belief about whether a debt was raised or referred to debt collectors based on what Mr Tudge had said?
I believed he did have his vulnerability indicator, but going through all the information from the coroners that I received back, there is no clear indication of this being done through the online compliance.
That is, following your request to the coroner for an inquest and the process that was engaged in by the coroner, you received information from the Coroner's Court provided to it by the department in response to the coroner's requests for information.
That's right.
Can I take you to the second page, which is up on the screen, just above the heading number 2, any other information, you'll see, thank you, the position set out there indicates that the department intends to exempt various information, and the second dot point relates to information that relates to applications for and any payment of any other benefits such as disability support pension. You can see that. Did that have some significance to you when you read that recently?
Yes.
And what was the significance?
They just weren't going to give them the information. So, yeah. I don't believe that the coroner's office was given any information to confirm that it was a OCI.
Or the role that any information the department had about Reese's pre-existing mental ill health
Yes, yes.
was related to the debt in any way. Ms Miller, you say various things in your statement about your various attempts to obtain information about Reese's passing, and I think you've indicated today that really you only come to a full understanding, or only came to a full understanding in the last month or so once you reviewed the documents that have been tendered today.
Yes, yes.
Before we conclude your evidence, I wanted to give you the opportunity to share what you would like about this commission and the role it's played in the gathering of information for you over the last 6 years.
It's been very difficult to obviously keep persisting with trying to gain the truth, and of course through now the Royal Commission, I have been able to obtain the truth, and I'm truly, truly forever grateful to everyone who has supported me throughout this whole time. When I first was seeing a lot of this information, it certainly broke my heart because I felt like I'd let Reece down not knowing a lot more than I think I should have. But he was certainly let down by the system. I find it extraordinary the lengths they have been to try and get me to stop being so persistent. And I truly, truly hope that this now sets up a precedent that you're working in public office, you are there to work for the people. So do your job and do it properly, you know. And it all became very sly and just everyone was lying and covering each other's backs, and it just really, once I saw all the information that we have, it was both heartbreaking, but also vindicating, seeing that we've been able to get the truth out for Reece. Yep. So I do thank everyone.
Thank you, Commissioner. I did not have any further questions.
Ms Hogan-Doran.
Thank you so much for your evidence. I don't have any questions for you. Thank you, Commissioner.
Thank you.
Thank you, Ms Miller. It's a harrowing story. Thank you for your courage. I think we could probably all use the morning break. We'll come back at 5:02.
All rise. Commission stands adjourned until 11:55. Royal Commission is now in session. Please be seated.
Take a seat for the moment. I'll have to get you to stand up in a minute. Yes, Mr Gregory.
Yes, thank you, Commissioner. The next two witnesses are Ms Katherine Prygodicz and Ms Felicity Button. They too are represented. Mr Go is here in case something arises, but I can indicate that
Mr Go.
I don't intend to traverse the question of their views of the settlement or of the instructions that they gave or advice they received in the course of the class action. So,
Okay, Ms Prygodicz, which one? Can I get you to stand, and Ms Button? And can I ask each of you, will you take an oath or an affirmation, Ms Prygodicz?
Yes, Council.
Oath or affirmation?
Affirmation. Thank you.
Affirmation. Thank you, Ms Button.
Affirmation, please.
All right, we'll get those delivered. Thank you.
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
The response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thanks very much. If you both sit down. Thanks. Yes, Mr Gregory.
Commissioner, if I start with you first, Ms Prygodicz, can you tell the Commission your full name?
My full name is Katherine Ann Prygodicz.
And your occupation?
My occupation is a secondary teacher, maths and science.
Ms Button, your full name, please.
Felicity Tegan Button, and my occupation is a registered nurse manager.
I stick with you for a moment, Ms Button. You're undergoing some further study at the moment? Or
Yes,
undertaking?
I am.
Yes?
I'm doing my Master of Business and Mediation and Conflict Resolution because I run a nursing business.
What is your work history over the last 10 years and study history?
My study history was I did my degree in nursing, then my master's in nursing, my double master's in nursing and education. And my work history was I was a teacher of nursing for both Diploma of Nursing students and Bachelor and Masters. And then I moved into the field of running my own nursing franchise for the community nursing.
You're looking to get the trifecta in Masters, are you?
Absolutely. I want to be able to run my nursing business both ethically and sustainably.
And you prepared a statement dated 6 February 2023, which has tended earlier today.
Yes.
And attached to your statement is an affidavit that was sworn by you in respect of class action proceedings.
Yes, correct.
And before I move back to Ms Prygodicz, you were one of the lead applicants in the class action commenced in the federal court, which challenged the lawfulness of the Robodebt scheme.
I was correct.
Ms Prygodicz, you too prepared a statement for the Commission dated 6 February 2023, and you annexed a copy of your affidavit which was filed in the class action proceedings in the federal court.
Yes, I did.
Right. In your affidavit for the federal court, Ms Prygodicz, you set out a little of your work history and your employment history. These proceedings are being recorded, so I should say I have to get you to give a verbal response to confirm various things along the way, which is not entirely natural, but...
Yes, I did, yes.
All right, thank you. And if you might just provide a brief overview of your work experience and your involvement in tertiary study.
Okay, I finished my science degree about 2001, and then I worked in industry as a quality control chemist for maybe 7 or 8 years. I went back to uni and did a teaching qualification. I went back to industry, in the pharmaceutical industry, worked as a quality control chemist. I did a little bit of sessional teaching at Monash University and a little bit of other sessional teaching for VSEC, Victorian Space Science Education Centre. and had a little brief period of unemployment, I think in 2012, maybe for a month or two. And then I went back into full-time work at CSL Pharmaceuticals as a quality control chemist. And the last 5 years I've been teaching at different government high schools, the first one being St Helena Secondary College, and more recently William Ruthven Secondary College in Reservoir.
You said earlier that you have background in maths or qualifications in maths and science developed through those degrees. Is that the nature of your teaching work?
It is, so I do teach maths and science, and I've also used maths a lot in my as a professional scientist.
Ms Prygodicz, you referred to a period of time when you accepted a position in a part-time capacity, I think, or casual capacity at Monash University, and that was in early 2012. And you continued in that role until the end of the 2013 academic year, is that right?
That sounds correct, yes.
All right. I should indicate we have hard copies of your statements and affidavits here. I might ask if they could be provided to each of the witnesses. Thank you.
Thank you.
Thank you.
Ms Prygodicz, what can you say about the consistency or stability of your work hours while you were employed in the science faculty at Monash University during that period?
So during the semester I was very, very busy marking exams, tutoring, demonstrating. However, during the summer period, there might have been 1 or 2 hours of work a week and sometimes no work. I was also unsure of the hours that I would be getting in the coming year, for the rest of the year until student enrolments had been finalised.
That is for the next academic year, starting in about February, late February, something.
February, March, yes.
All right. And did that lead you to apply for New Start allowance during the summer break?
It did. Yes, Mr Gregory, that was my reasoning for applying.
You describe in your affidavit that you received $4,068.28 of social security payments during the period which was later asserted to amount to a debt in respect of the Robodebt scheme.
That is correct.
What do you recall of receiving the letter which notified you ultimately of the debt? Sorry, rather, how did you come to be aware that you had a debt?
So I first became aware through a series of phone calls. I did eventually receive a debt letter after the phone calls, after visiting Centrelink, I believe, to query this. So all debt letters had been sent to an address that I hadn't resided at for a very long time.
And in terms of the period of time that you did receive support from Centrelink, did you maintain regular contact to update Centrelink about the income you received?
I did fortnightly update them.
Yes.
And I, to the best, of my ability, reported the hours that I was working and the money that I had earned.
And at least at the time that you were receiving Centrelink support payments, the address that you lived at then was kept current with Centrelink.
So it was at that time, yes.
You explain in your affidavit that you didn't understand the necessity to maintain current residential information with Centrelink after you stopped receiving Centrelink benefits.
That is correct.
And as you've just said, there was a period of time when debt letters were going to addresses you lived at a much earlier point in time.
So at the time that I was aware of the debt and getting the phone calls. These debt letters were sent to a address that I didn't live at, yes.
You indicated that you were on a fortnightly reporting regime with Centrelink. Did you do most of that online?
I think I did return forms. I'm pretty sure I remember going into the office and handing in a form and standing in a queue and handing a form in. So I couldn't 100% be sure if I did every single fortnight's payments in person, but I do recall going in there and handing in forms.
The telephone call that you received when you found out about the debt was from a person who initially identified themselves as from Probe Group. And did you come to understand that that was a debt collection agency?
Not easily. So at first I thought that they might be an online scammer or some sort of hacker trying to get some identity, maybe steal my identity. So that could sound strange, but the phone calls were not during business hours and I was a little bit suspicious of them. So, yeah.
And do you recall anything particular about that first phone call?
The first phone call, they asked personal information of me to verify my identity. And I wasn't going to divulge my identity to a random person that rings me up on the telephone. Even if they do say they're acting on behalf of the government. So...
Did the person on the telephone say anything to you about the reason why they were calling you?
They said that I owed the government money. I think they mentioned that that it was very serious, that I had been a bit naughty, that I hadn't reported information correctly. And I said, look, I'll wait for an official letter from Centrelink for this. And this is, yes, I'm not going to give you any information over the telephone about this. So,
and to be clear, this phone call, according to your recollection at the time you provided the affidavit, was 11 January 2017.
I couldn't be sure of the exact date, but that sounds about right. So I would have to look through and...
The next thing that you refer to in your affidavit was on 9 July 2019 that a tax refund to you of approximately $140, I'm referring to paragraph 22 here, for the financial year ending 31 July 2018 was garnished by the Australian Taxation Office. It's certainly, yes, it might be easier to view it on the screen.
Lovely. Yes.
And as you say, it was only at that point in 2019 that you realised that you had an asserted overpayment debt. See that?
That is correct.
All right. Now, it obviously had an impact on you, the garnishee of your tax return, both financially and emotionally.
It did. I was surprised and very stressed out, a little bit shocked. I've been very shocked. To the best of my knowledge, I'd reported everything accurately.
What were you able to discover about how the debt had been calculated?
Not very much. So I went to Centrelink. I asked them for more information. So in person, I went to the Moreland Road office and asked them for some more information about this. And they said, look, you need to provide your information, pay slips and bank statements and so forth. So I believe I provided all of my bank statements to them shortly after the overpayment, alleged overpayment. So
One of the features that you talk about was the difficulty you had engaging with Centrelink after in the course of 2017, attending offices outside of working hours or waiting on the phone during lunch hours when you couldn't always get through. Your statement conveys, or rather your affidavit conveys, that you experienced real difficulty in that regard engaging with Centrelink.
absolutely. Yes, Mr. Gregory, yeah, absolutely.
You also refer in your affidavit to a departure prohibition order. How did that come up?
It was mentioned during one of the phone calls with Centrelink that it was best to comply with repaying the debt, even though I wasn't sure how it was calculated, because a departure prohibition order could be, I guess, instigated against me. I wouldn't be able to leave the country, and that concerned me, that I wouldn't be able to visit friends or family in New Zealand.
You refer particularly to your attendance at the Centrelink Moorland office on 17 July 2019 in person to try and get to the bottom of it, as I understand it, of what was going on. What do you recall of that day?
I recall that they wouldn't accept any of my written letter asking for information or my bank statements. They wouldn't, which were on a USB stick, because I could have viruses that would infect their computers. They did get me to talk to someone on the phone. I did log into their computer portal and access my Westpac bank statements and print them all off. And I left this at the front desk of the Moorland office with as social security officer there, and left the building. I did have a security guard standing behind me for a bit. I did get a bit distressed and upset and agitated. So they did have a security guard standing close to me, maybe a metre or two away. Yep. At this point, at this time. Yep.
You said that you spoke to someone on the phone. Was that from a phone inside the Centrelink office?
It was, yes.
And the computer portal that you accessed, that was a computer portal, a standalone computer portal within the office?
That's correct. So they wouldn't accept the PDFs on my USB stick because I may have had viruses on there that would infect their computers.
And so you downloaded them from the computer in the office?
Yep.
And printed them out. But what about the telephone call? What was the purpose of the telephone call as compared to speaking to someone over the counter?
Oh, they said that they would refer me to someone who was more able to help me and I should call someone else. So that's what I did from memory. That was that they couldn't help me and that there was a number that I could call and I could speak to someone.
You came to lodge an application for review of the alleged debt in about August 2019?
Yes, I did.
And then in October 2019, you made a partial payment of $400 towards the debt?
Yes, I did.
And what motivated you to do that?
I wanted to show that if I was in error, I was, genuine about paying a debt. I wanted to be compliant so that I could travel overseas. So, various. I didn't want any more money to be taken from my bank accounts. So it was garnished from my tax return. I was worried that money could be taken out of my Westpac account. So I thought the best thing was to comply and pay some money towards the debt.
Had money been taken out of your Westpac account by that point in time?
No.
But you were concerned that it might be?
I was concerned that it could be a possibility, yes.
And you go on in your statement at paragraphs 38 and following to believe that there was a legal obligation to pay the money back because that's what you were told during phone calls with Centrelink staff.
Yes, that is correct.
And you said you were nervous about getting into a dispute with Centrelink.
Absolutely, yes.
And was that because of the mention of the departure prohibition order or other reasons as well?
I think the departure prohibition order and potentially having the money taken out from my Westpac bank account in a lump sum payment.
Thank you. Ms Button, I might turn to you and ask you some questions about how you became aware that you had an alleged debt.
Yep. So, thank you, Councillor. When I think it was 2016, I received a letter saying that I had a debt raised against me. And at the time, I think my oldest daughter now, Ciara, she's now 6, she was just born. So I sat on it for a little bit before calling the office to ask about it, and they said that if I don't agree with it, I should ask for a review. But in the meantime, I set up a payment plan to pay it back because throughout the time of incurring this debt, I was on youth allowance. I had over 30 different casual contract part-time PCA jobs. So I assumed, well, if there's been an error, then I should probably address it. So I set up a payment plan and didn't think anything of it, just continued with my day-to-day life on that payment plan.
You indicated that you had a large number of employers.
Yes.
What was the situation in which you had multiple employers?
So I was a university student. I started with my diploma in children's services and then wanted to move out of the child education field because I wasn't suited to it, and decided nursing was the right career path for me. So I did my Bachelor of Nursing at Monash University, and through my time of studying, I was also living independently with a housemate. So we had to pay bills, had to pay rent, but at the same time, I was at Monash University, so it was a very heavy study load, lots of placements for clinicals, and so I had to find work that would fit in with university and still allow me to put food on the table. So,
you identify in your affidavit that the period of time over which the debt was alleged was a couple of years from 2012 through to 2014.
correct.
And during that period of time you were studying.
Correct.
And you had, as you say, a large number of employers.
Correct.
The payment plan that you entered, did that continue without interruption?
No, it did not continue without interruption. I set it up and I asked for a review. I did not get my review and they cancelled my payment plan without telling me, but I was not made aware of that easily. Would you like me to tell you how I was made aware of that?
Please.
In 2017, my daughter had just turned 1 and she was extremely sick. So I took her to the doctors. Turned out it was an upper respiratory infection. And I went to go pay for the doctor's appointment and my card declined. And I checked my banking app on my phone and $11,500 was overdrawn in my account at the doctor's office. So that's how I found out that my payment plan had been stopped. And it turns out it had been stopped a few months beforehand, but no one notified me, nor by telephone, email, letters or anything. And I called Centrelink to ask why they had taken so much money out of my account, to which they responded, "It's not in our hands, it's with a debt collector, you need to call them." They didn't tell me which debt collector, they didn't give me any contact numbers on how to contact this debt collector. So I called my bank to find out who had taken the money, and then I found out it was, I think, Dun and Bradstreet. So I Googled them and called them, and they said, "Sorry, but Centrelink has referred this to us and you owe this money." And then I said to the lady on the other end, "Well, maybe I should just drive my car off the road because I can't survive on no money. And I can't, sorry. And I can't.
Take your time.
And I can't pay for my daughter's medication or doctor's appointment." And then the lady on the other end was really nice to me, and she said, "That's okay, I'll get somebody to review this." And I stayed on the phone. I was on the phone to them for a few more minutes before another lady came on the phone and said, "We'll return the money to you in the next 24 to 48 hours and set up a new payment plan." And so that's what happened, and then the money was returned to me in 48 hours, and I was able to buy Ciara medication and the GP bulk billed me, thankfully. Sorry about that.
Right, I think we're just going to
I just
get
grab
the
a tissue?
tissues passed down.
Thank you. Sorry, that's probably the only time that's the only hard thing to talk about. The rest is fine.
Can I just ask what was going on there? Had they stopped your benefit and you didn't know? Or?
So I had actually stopped receiving benefits from Centrelink in 2014 or 15 when I finished my studies. So by 2016 I was working, I had just come off maternity leave, and I was working casually as a registered nurse in an aged care facility and doing a bit of teaching. So I wasn't relying on Centrelink at that point. So I think,
There was some sort of garnishing of your bank account.
They just took the lump sum out of my account in one hit. The debt collector did, but at that time I wasn't on any payments. I was just receiving what income I was from employment. So that's why it was confronting, because it wasn't anticipated. Thank you, Commissioner. Sorry, Council. Thank you.
Not at all. When you were first notified of the debt, what was your attitude towards whether you did have a debt and how you might go about repaying it if you did? What was your position?
My very first time when I found out I had a debt, I was apprehensive about it, but I thought there was possibly some reasoning to it, because I knew that I had a lot of employers, and I knew that I was reporting on a fortnightly basis what I believed my income to be. And at the time, when you have a lot of different employers and you have to factor in penalty rates, weekends, night shift, nauseous linen allowance for a multitude of different employers at different pay rates, my goal when I was reporting my income every fortnight was to be as accurate as possible, and where I wasn't, I'd try and adjust it the fortnight after. So I knew that there was a possibility that I had a debt, so I never wanted to dispute the fact that it existed. I did want to I wanted them to answer how they came to that amount, because the original amount was $11,000. And when I called up to, one, set up a payment plan, and two, ask for a review, because it said on the thingy that if you don't believe that this is the right amount, you can ask for an internal review. The person on the other end just basically told me it is what it is. And when I asked how did they come to that, they said, "Oh, we averaged out we looked at your income." And I'm like, okay. And I don't come from a maths background or anything like that. I'm a nurse. We're good with numbers, but not that good. So, but when I asked for a review, they came back with a figure that was then higher than the initial one. And I asked why that was the case, and they didn't give me an answer to that either. They just said that they recalculated it. And at no point in that process did I feel like I had the right to fight them about that, because they were the professionals and I was the civilian who's incurred a debt. So, yeah, I basically, I knew that there was a debt. I don't know how it got calculated. I don't know how they came up with whatever figures they did. However, it was recalculated 3 times to 3 different figures. And I just wanted to cooperate as much as I could to repay it.
And the recalculation, did that occur after you provided some information to Centrelink?
The first one didn't. So the first recalculation they did was before I provided them any evidence. It was just when I asked for an internal review. And then the second time they recalculated it was actually after I had approached... No, sorry, it was before I approached Gordon Legal. They asked me for pay slips, which I couldn't provide because it had been, 2-3 years ago and I didn't know any of the employers anymore. So I gave them bank statements, and after I gave them bank statements, they recalculated it again and increased it again.
Of course, the catch with bank statements is if there are allowances in the amounts you've received, they're not going to know the difference, and even though they may not be part of your income for the purposes of entitlement, you're stuck with it.
Correct, Commissioner. It's very tricky.
You referred to Gordon Legal, and obviously you became a lead applicant in the class action. Can you describe how you felt about taking on that role?
Initially, I stumbled into the class action because I saw it on Facebook and I thought, no one's going to want to hear from me, but I'll just kind of make my comment and tell my story. And somebody listened and they contacted me and they said, oh, you should really contact Gordon Legal through the correct avenue, not through the Facebook post. So when I contacted them, I spoke to Guy first, who was one of the lawyers, and I felt nervous, to be honest, because when I had asked Centrelink to review my situation even before legal proceedings, I felt like they punished me by reviewing and increasing the debt, and so I assumed that they would do the same again if I kind of made more noise, and I was correct, they did. Because after Gordon Legal asked for it to be reviewed again, they increased the debt again. So I was very nervous and I knew that I had a lot at stake, but I also felt like it had to be done. The ball was rolling.
Were you in a relationship at the time?
Yes, when I contacted Gordon Legal, yes. I was with my husband, my then fiancé, now husband.
And did you two discuss what was involved in?
We did. We knew that. So Gordon Legal's representatives made it very clear the risks that we were going to undertake by taking on the government, including the possibility that if we lost and didn't have indemnity insurance or whatever, that it could cost us millions. And I turned to my husband and he was reluctant at first, and he basically said, are you sure you want to do this? Is this the hill you want to die on? And I said, well, worst case scenario, I can file bankruptcy if we lose, or I can sign a Part 9 agreement. But my reason for taking that risk was because if we don't do this now, and Ciara or Penelope need social services in the future when they want to go to university, what's stopping this from happening to them and then them having to fight for something that I could have fought for years before? So we knew the risks, we were willing to accept them. We knew that I looked into what's involved in bankruptcy and Part 9 agreements, so I knew that we couldn't lose our housing and we couldn't lose our car because they're necessities, they're essentials. But we can live without luxuries. We've done it before, we can do it again.
You refer in your affidavit to some, what I might describe as mental struggles when you first found out about the debt.
Yes,
This was back in 2017.
correct.
Did that play on your mind throughout this period as well?
Very much so. Very much so. There have been many moments through this ordeal that's plagued me and my mental health, especially early on. A lot of thought process around whether or not I was a good mother, whether or not I should be a mother or a partner. Particularly early on when they took the money from me, I always kind of had this thought of if I had died, if I had killed myself, then I wouldn't be a burden to my family and to my daughter at the time and my husband, because he was very supportive and I didn't feel like it was fair for him to watch me have to go through this and ruin us financially. And then later on in the class action, just thinking, you know, worst case scenario, what happens if I become a public pariah? What happens if I'm labelled as a dole bludger or a system rort or a system cheat when that couldn't be further from the truth? So there's been a lot of mental health impact on me from my engagement with Centrelink.
Can I turn to you now, Mrs. Prygodicz? Did you have any of those concerns when a debt was alleged against you?
Not to the extent that Felicity had. I don't have any dependents. I don't own a house. At the time I had 2 Staffordshire Bull Terriers to look after, so I guess my commitments and finances weren't as much of an issue as if I'd had a family and so forth. If it had, I was reassured by the indemnity clause, and I trusted the advice of my legal team, Gordon Legal. So it seemed a risk, and the principled thing to do. So it seemed a risk worth taking. I didn't really think there was a risk because it was underwritten by Gordon Legal, and it seemed the principled thing to do. So.
You refer at paragraph 49 of your affidavit to the asserted debt having a substantial impact on you because you consider yourself to be very honest and diligent. What can you say about that, the relationship between the allegation of a debt and how you viewed your character?
So it impacted me because the onus was that I had done, the presumption was that I had done something wrong, that I'd reported things incorrectly, that I was a dole cheat. This is how I perceived it. And as a teacher, you sort of have a responsibility to exist in the world as a person of repute. Also, my partner's family didn't believe that it was incorrect. They suspected that I had done something a little bit dodgy and that I had lied to the government. So so this made me feel a bit. It made me feel pretty bad and distressed, for lack of better words. Mr. Gregory.
The passage that's been pulled up on the screen refers to a statement made by your partner's mother, I think, that she didn't understand why you would have a debt to Centrelink and that if you had been honest and transparent, no debt would have arisen. How confident were you that you didn't have a debt and that you'd reported correctly?
I was confident that I didn't have a debt. couldn't fathom why I would. I was pretty meticulous at recording numbers and those sorts of things. However, I wasn't sure that I could prove that, if that makes sense. So, does that answer your question, Mr. Gregory?
Yes. You referred earlier to what you considered to be the principled thing to do, and that is joining in the class action. Your name, of course, appears as the first applicant on the judgment. How did you arrive at the position that the principled thing to do was to challenge the asserted debt?
I hoped that if my debt was proven to be incorrect, then other debts that had been calculated this way would also be proven to be incorrect, and other people would get their money back. So that was what I thought was the principled thing to do, and I had the opportunity to do that, so I took that opportunity.
If I return to you, Ms Budden, did you have the same sense of appreciation that a class action obviously didn't just relate to you or potentially your children?
The principle on, the principle on why we needed to fight it is the same, but mine was slightly different in the sense that I wasn't looking to prove that I didn't have a debt. My objection to the Centrelink Robodebt process was the process itself on how they managed people who had a debt, because I don't inherently believe that anybody, or for the most part the majority of our society, wants to rot the system. I think the system itself was a very convoluted and difficult one to navigate, particularly for a person in my situation with multiple employers, casual work, managing a lot of different external stresses. And the way Centrelink managed this program, I think, was done unethically and quite heavy-handedly to, people of a vulnerable population. We're not talking about people who are immensely successful and barristers and doctors. We're talking about a vulnerable population of people who are still studying or on disability or in low socioeconomic situations, and to terrorise those populations of people, I thought was the way they went about it was really wrong. So that's what I was disputing, not the fact that I had a debt. It was the way they handled that debt.
In the course of the process, that is the process of the class action, I gather your debt was recalculated again according to various documents?
Yes. So as part of the class action, I got a freedom of information release of my information, which I gave everything to Gordon Legal because they're a lot smarter than me when it comes to money. So they had their forensic accountants analyse that, and then Centrelink also reanalysed it with their forensic accountants. Both Gordon Legal and the government came to two very different figures, and the government then increased my debt again. And when I asked for an explanation on how that was recalculated, I was told it was an algorithm, and I wasn't given. I still to this day don't know how they've come up with the figures that they have with their 3 or 4 recalculations. I understand there's a debt, but I don't understand how it's come to such a figure. So, and I don't think I'll ever know.
I probably should correct one thing. I think you referred to the debt collector as Dun and Bradstreet.
Yeah, I can't remember which one it was.
Your statement says ARL.
ARL. Aren't they all the same?
So, Ms Prygodicz, the class action had a slightly different outcome for you. And what was that?
So my debt was cleared. So I was very happy about that.
How close did the trial get?
Sorry,
How far along the process of the class action did you go towards trial?
I think we're maybe about 70% of the way. Could be wrong, but that's, yeah, a rough.
How were you?
Oh, sorry.
Ms. Button, what's
I've
your
misunderstood
recollection?
you. Sorry, Mr. Gregory, I've misunderstood. Yep. Could you repeat
Could you
your
repeat
question?
the question?
How close did you get to the trial after commencing the process?
Very close, I think we did. I think we were pretty close to having to go to trial before. You might need to redirect the question back to our legal team because it's probably a bit fuzzy for us.
Yeah, the time frames are a bit blurred to me. But
Shouldn't give evidence from the bar table, but I think I remember the day it settled and it was the first day of trial.
Yeah, thank you. I thought we were pretty close.
it was,
Yeah, very close,
It
'cause I-
was the first day. It was. Thank
Yeah.
you. Yep. So
Was there a prospect that you were going to give evidence, Ms. Prygodicz?
I think there was a possibility. But,
Yes, Ms. Button?
I remember vaguely a conversation with our legal team, and there was a very strong possibility that we were going to be asked to come up to the city for trial and to give evidence, and so they were preparing us for that. So I remember the settlement, it did happen quite fast, the communication with us and the team. They communicated one thing to us, and then a few days later it was, okay, let's settle before, or the government's agreed to settle, something like that, before trial. But the whole process was so fast, and there was definitely a prospect of us having to sit in and give evidence. I only remember that because I had the conversation with my husband and I was terrified.
Yes, that's what I was going to ask you. How did the impending trial?
That was very, very scary because by that point, I don't mean to talk for us, but I remember at this point I had established a good career for myself and a good name for myself in my community with my nursing, and I was really worried on how this was going to affect my work and my reputation, because you just don't know how the public are going to perceive a situation and what the media is going to do to kind of angle things in a more palatable way to get views, especially with the world of social media now. So I was quite scared of the prospect of going to trial.
I see you're nodding, Ms. Prygodicz.
I was also concerned about questions students might ask, questions that, my professional reputation, possibly my character being assassinated by social media, and whether people rightly or wrongly supported me in the application. I was very concerned about all of those things. So I wasn't looking forward to a trial, but prepared to go to trial and give evidence if it was required.
You, of course, were each one of 6 lead applicants in the class action. You undoubtedly spoke to the other applicants in the course of the matter.
Only in Zoom calls that were with Gordon Legal, so no, not on a one-to-one personal conversations, no.
In terms of reflections on the circumstances which led to your debt, Ms. Prygodicz, have you had the opportunity to formulate some thoughts about what brought you to the class action and how that resolved and the position you're in now?
Oh, I'm very happy with the position that I'm in of having no debt, and the debt was for about $3,000, I think, from memory. The exact figure is in the documents, but I felt exonerated that I wasn't going to be labelled as a dole cheat, and I've hoped for other Australians too that they also had some of their debt erased or reduced by the class action and having their debts recalculated.
Did your partner's mother apologise?
No,
She
Commissioner.
should have really, doesn't it?
I think she believes that it is an error that the staff made. Say that the staff had made an error.
All right.
Ms Button, have you had the opportunity to formulate some of your thoughts, reflecting on the past 6 years?
Look, my situation's obviously different than Katherine's. I wasn't looking to be exonerated or anything like that, and my debt obviously still stands. For me, this class action and this subsequent commission has never been about erasing debt, but more highlighting a flaw in a system that needed to be fixed for my kids. I mean, I want to do it for the community, but ultimately I'm doing this for my kids and your kids and everyone else's future generations, because if the government can get this wrong now and we don't learn from it, then we're doomed to repeat history and then further generations will suffer. So the class action did exactly what it was meant to do, which was open up the conversation as to how it happened, and it brought forward this Royal Commission, which I'm very pleased is happening. Because this, to me, is the resolution, is to have a formal inquiry into how the government got something so egregiously wrong. So that's my resolution. It's not a personal one, it's more of a community one, a societal resolution.
What about your approach to applying for Centrelink?
I will never apply for Centrelink again, and I hope that this is highlighted in the teleprompter, ever. I will live out of my car. I will live on the street. I will sit outside Southern Cross Station if I have to, but I will never, ever apply for Centrelink ever again. And then it's not because I might never need to, it's because I never want to be put in that position again, feeling so vulnerable, feeling like a strain on society, feeling like I'm the problem. I'm never going to put myself in that position again. And if my children need Centrelink, I'll do everything I can first before they use it. I will tell them exactly what my mum told me, which is stay home until you buy a house. And don't rent.
What you wish for.
Yeah. I know. They'll probably stay home till they're 50. But no, if I can avoid using social services, I absolutely will at all costs. It's not worth the pain.
Ms Prygodicz, any concluding words?
Very similar to Felicity. So I need to make sure in life that I don't use social security services or collect money from Centrelink. So I've made sure that I have a lot of savings, and hopefully will never need to, unless I get really, really sick, apply for Centrelink repayments ever again.
Ms Button, I can see.
Can I say one thing, Council?
Yes.
At the time, I don't want anyone to be misconstrued by my opinion on Centrelink. At the time that I used Centrelink, it did exactly what the system was meant to do. It supported me through very important studies so that I could be a productive member of society. I have my nursing degree because of it. I have my master's. I'm doing another master's. I have a successful business. None of that could have been achieved without youth allowance and Oz study. So the system is there for a reason, and there are products of the system like myself who are proof that the system is there to be beneficial. But when you use a system to punish people for mistakes or punish people of a vulnerable category because you can, then you're breaking a system you're breaking the one thing that you've developed that's going to create productive people, if that makes any sense, councillor. So I'm thankful for Centrelink. I'm thankful for the fact that I went from having no education and living on, allowances to having a successful business and helping my community. I'm very thankful for that. But I'm not thankful for the treatment after I came off the system and how hard it was to get off Centrelink. And I think people forget that. Centrelink is a good crutch, but to come off Centrelink and to be a productive member of society is very difficult. And they don't make that easy to not rely on them. So that's all I have to say on that.
Thank you.
Yeah, I just, sorry to interrupt. So I agree with you, and I would also, I've received Austudy and those sorts of benefits as well, and use them to improve my life. And I hope that it's something that's looking forward in the future, that the system can be a bit more robust and maybe audit itself more with more transparency. That's all. Like, people should be able to use it and not have fears about using these government services.
Thank you. Thank you, Commissioner.
Ms Hogan do it.
Thank you, each of you, for your evidence. I don't have any questions for you.
Thank you.
Thank you.
Close enough to lunch, do you think?
Yes, thank you.
Thank you for your time. You've both entered Australian legal history, as you probably appreciate. So congratulations.
Thank you.
Thank you, Commissioner.
And you're excused and we'll take the lunch break.
All rise. The Commission stands adjourned until 2:30 p.m. Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Yes, thank you, Commissioner. I appear with Ms Berry this afternoon. The next witness is Ms Lees.
Ms Lees, will you take an oath or an affirmation?
Affirmation.
Okay, could you stand and we'll just get that delivered?
Response is I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Take a seat. Yes, Ms Gregory.
Thank you. Can you tell the Commission your full name, please?
Megan Lees.
And Ms Lees, you were served with a notice to give evidence, a notice to give a statement and produce documents NTG-0161 dated 10 January 2023.
Yes.
And produced a statement in response dated 24 January 2023.
Yes.
And that statement's been updated to reflect some additional document numbers or correct document numbers since that date.
Yes.
Thank you. Are the contents of that statement true and correct?
Yes.
Thank you. You were, for a period of time, the Chief of Staff for Senator Payne when she was the Minister for the Department of Human Services.
Yes.
And that period, as you set out in your statement, was from 29 November 2013 to 20 September 2015.
Yes, that's right.
And thereafter you were appointed as Minister Payne's Chief of Staff from 21 September 2015 until 12 October 2018.
Yes.
That was in respect of the Department of Defence, or Minister for Defence. The topics on which your statement was sought related to the processes for briefing the Minister generally, including briefings from the department, but also in respect of the Minister's involvement in new policy proposals and attendance at expenditure review committees generally. In that context, you were referred particularly to a brief B15/39, which was a brief created by the Department of Human Services dated 15 January 2015. If I could have Exhibit 5207 placed on the screen. That is an email from Ms Ridderhoff to yourself on 15 January 2015 and at about 22 minutes past 8 in the evening.
Yes.
And it attaches a couple of appendix, but one is B1539, cover brief for Minister Payne as it's described in the attachment.
Yes.
All right. The reference in the first paragraph to the Secretary is a reference to Secretary Katherine Campbell.
Yes, that's right.
And the Minister there, of course, is Minister Payne.
That's right.
Do you have any independent recollection of the events surrounding brief B1539?
My recollection is not great, but I have put together what I can from looking at my emails and other documents that have been produced through this process.
Well, in that context, you became aware, at least in the preparation for your statement, that B1539 was never signed by Minister Payne in the usual way. That's right?
I certainly didn't see a copy that I could find that it was signed.
Okay. Did you see any evidence that had been returned to the department unsigned?
I don't have that either.
Okay. What was described, if we turn to the attachment, which is Exhibit 5208, should say, Ms Lees, if you would like to look at the hard copy, I think there is a bundle which contains the documents I'm referring to, and it's now at tab 6.
Yes, have that.
You have that. And if we could turn, please, to attachment B, page 0.0161, which is 11 of 26 at the bottom. The PAYG clean-up measure, as it was described in this brief, sent to you on 15 January 2015, later became a new policy proposal considered by the Expenditure Review Committee on 25 March 2015. What was it your understanding at the time that the brief was forwarded to you that there had been discussions between the Minister for Social Services, Mr Morrison, and Secretary Campbell?
I think this one was being prepared for a discussion between Minister Morrison and Secretary Campbell.
Yes. So you weren't aware of any discussions preceding this?
No, I have no recollection of
Not
that.
to your recollection? No. Right. Subparagraph E refers to the need for a change of policy to enable the application of income smoothing to assess a customer's income and the possibility for a need to change legislation. Did those concepts have any particular significance to your recollection to Minister Payne?
Not particularly. It was fairly commonplace to say this may require change effectively, and we'll continue to provide advice on that, is the inference from that paragraph to me.
Yes. Do you recall whether you were aware at the time about whether there were difficulties passing legislation if that was required through the Senate?
I'd have to reflect on that. I don't know that legislation is ever easily passed through the Senate, and I can't recall what the numbers in the Senate were at the time.
Right. And you don't recall any conversations with the Minister about that?
No, not in particular about this. This is a brief that has many proposals in it, so not particular to this issue, no.
All right. Through your review of documents, Ms Lees, have you been able to establish that Minister Payne received a copy of B1539 at some point prior to a meeting on the 20th of January 2015?
I'd have to refer to my statement. I'm fairly sure there was an email forwarding it to her.
If you go to tab 8 in that bundle, there is an email from Ms Ridderhoff again, directly to Minister Payne.
Mm-hmm.
Is that the email you're referring to?
It certainly is.
And who was Ms Ridderhoff so far as your role and her role was concerned within the office?
Ms Ridderhoff was one of 2 departmental liaison officers, so she was a staff member of the Department of Human Services outposted or posted into the Minister's office to facilitate the flow of information between the department and the office.
The provision directly by the DLO, that is Ms Ridderhoff, to the Minister, was that unusual in terms of communication of information?
No, quite often did this because the Minister travelled and worked across sites, so briefs would often come into the office in Canberra and be forwarded to wherever the Minister was. I'd note on this one it also copied in her executive officer who was asked to make sure that the Minister received it, so she probably would have printed it to give it to the Minister.
And who's the executive officer?
Katherine Bratuza.
And is it the case that Ms Bratuza would ordinarily travel with the Minister wherever
She was normally located where the Minister was.
Right.
I must clarify that if the Minister was in one of her usual offices, so the Minister had an electorate office, a Sydney office and a Canberra office. If she was travelling round to, say, a Services Australia site, Katherine wouldn't necessarily accompany her.
That email in the second line of the document on the screen could be taken down. The email in the second paragraph, I guess, commencing Katherine, refers to the minister when she is in the CPO. Now, you explain this in your statement, but can you do so?
Yes, so the CPO stands for Commonwealth Parliamentary Officers. They're a suite of officers in the Sydney CBD, in which ministers and the Prime Minister keeps ministerial offices. Quite often, so the minister had an electorate office in Western Sydney and a ministerial office in the Commonwealth Parliamentary Offices.
All right. And does that indicate to you that the minister was in the Commonwealth Parliamentary Office at the time the email was sent, or was soon to be there?
Soon to be there, I would assume.
Okay. And just for completeness, the attachment is behind tab 9. It is Exhibit 2500.
Yes.
Okay. Thank you. Can I take you to tab 11, which is Exhibit 5211? This was another document that you identified in the course of preparing your statement and responding to the notice. It's from Melissa Wann, who I take it you understood to be a member of the department involved in the briefing.
Certainly understood she was a staff member of the department, yes.
And it is to Melissa Golightly, and is it the case that you recall Ms Golightly being a Deputy Secretary in the department?
Yes, I do.
And in the body of the email, a few people are referred to. There's Ms Ritterhoff, the DLO.
That's right, that's Kate.
And yourself.
Yes.
And it refers to you and Kate clearing the brief, and it appears communicating that the minister had an electronic copy. Do you recall anything about this other than what is recorded there?
Only what's recorded.
And a reference in the second sentence to Kate arranging for a hard copy in the Sydney office is a reference to the CPO, Commonwealth
That's
Parliament.
right. And I believe refers to that previous email that you put up.
Yes. All right. Another document that you located in the preparation of your statement was a calendar invitation for 20 January 2015 from 10:30am to 11:30am, which was described as a meeting Katherine Campbell / Melissa Golightly / Mark Withnell / Megan. You understand that to be, I take it, and certainly your statement suggests that that was a meeting on the 20th of January in the Commonwealth Parliamentary Offices between those people, including yourself.
Yes, I believe that's what it is.
And particularly the location for the meeting room, according to the calendar invite, was the bubble room, which was a room at the CPO.
It was a particular meeting room in the CPO.
Yes. And that chronology leads you to conclude, I take it, that B1539 was the subject of, in part, that meeting.
Yes, I believe that was the brief was prepared for that discussion on the 20th of January.
Yes. You haven't been able to locate, or rather you have not located any of your own notes of your attendance at the meeting or what was discussed?
No, I haven't, Mr Gregory. It was quite some time ago.
All right. But to confirm that, you also located a daily outline of the minister's schedule in relation to 20 January 15, which records the same meeting as the invitation that you just referred to.
Yes, found that in my emails.
In your emails. And I think you also found in your emails some flight information about you flying from Canberra to Sydney.
Yes, I can confirm that I flew to Sydney on that day.
Thank you. Can I take you to tab 23A in that bundle, Exhibit 5221? The email is from Marg Park at Parliamentary Services to the Deputy Secretary, Ms Golightly, and a number of other people, including the Secretary's office, Mr Withnell and others. The date is 23 February 2015 and the attachment is B15125, Minister Morrison's signed brief. And you'll find the attachment behind tab 24. Before I come to that, you will note there that the Minister's office has advised that Minister Morrison has signed B15/125, see attached scan. Pausing there, the reference to the Minister's office in that email, is that Minister Morrison's office?
That's unclear to me from this email.
It could be.
It could be either.
Right. And the indication that Minister Morrison has agreed to pursue some options is what is marked on the attachment. But speaking generally, do you recall what the ordinary process would be in respect of the pursuit of options in the context of a briefing about potential new policy proposals?
Could you ask that one again, please?
What I'm getting at is that the date is towards the end of February. The budget is in May. The brief deals with potential new policy proposals, which Minister Morrison has agreed to pursue. What's the process from your experience about what has to happen in order for that option to be pursued?
Okay. One thing to be clear about is that in regards to portfolio arrangements, Minister Morrison was what we call the senior minister and has responsibility for taking forward the portfolio budget submission, which has all of the proposals for any measures across that portfolio into the budget process. So that original brief you pointed at, was it 39, I think?
1539,
1539. Yes. That was a draft brief prepared for Minister Payne to consider to provide to Minister Morrison that had some 30-odd potential proposals in it. She went through a process of looking at what was there, informed by previous discussions that she had had with Minister Morrison when he came into the portfolio, because he, I think, got sworn in just before Christmas the year before, and talking with the department about what the range of options were. So by the time this brief B15125 goes to Minister Morrison, it is substantially abbreviated from the number of proposals that were first put forward to Minister Payne in B1539. So you go through a process of refinement and understanding of options, and this brief was prepared for the senior minister to decide which of those options he wanted to know more about, knock out of the mix, or agree to continue to take forward. And when I say take forward, those options would have been worked up in more detail between Department of Human Services and Department of Social Services in this case, including things like costings. None of costings information is in the proposals at this stage. They get worked through and costed up properly. The parameters of how the measure will work get worked through till you get to a final new policy proposal template completed, which goes into what they call the portfolio budget submission, which then goes to government for consideration by the Expenditure Review Committee, which is a subcommittee of the Cabinet. That's a very short summary of a long process that starts, as we saw, around the Christmas, New Year period.
We know from other documents contained in the bundle that the Expenditure Review Committee ultimately considered the new policy proposal referred to in this attachment, B15125, on 25 March 2015. In terms of time frame, the period here is just a little over 4 weeks, it would seem, for that process to be undertaken from the signing of the minute to actually consideration by the subcommittee of Cabinet. In the context where legislative change was identified as being required for the measure, what can you say about the available time frame to consider that?
I don't think it's necessarily a more abbreviated timeframe than you would see typically across portfolios in my experience. Quite often those sorts of considerations are occurring while policies are being developed. It's probably slightly abbreviated because there would have been a little bit of lost time because of the portfolio change just before Christmas, and the need to get, or the need for Minister Morrison to feel comfortable with the portfolio. It's a very broad portfolio with many responsibilities, to get comfortable with those. So there may have been some effect, but it's not out of the parameters of the normal. Quite often across many portfolios there are compressed activities towards the end of the budget cycle.
In this particular budget cycle and this particular portfolio, were you aware that a lot of the new policy proposals which comprised the DSS portfolio budget submission were largely advanced by 28 February 2015?
No, because they would not have been visible to me. We were junior minister and only saw those aspects that were related to the Department of Human Services.
Can I take you to the attachment, Exhibit 2669, behind tab 24? My question here relates to the dates. You'll see the stamp in the top right corner, received 12 February 2015, DHS DLO. Does that indicate that the document was received in Minister Payne's office by Ms Ridderhoff or the other DLO on the 12th of February 2015?
That's what that would lead me to believe, yes.
Right. And yet we can see the Minister for Social Services, whose signature is redacted, has signed it on the 20th of February 2015. That is after it's received in Minister Payne's office. Do you recall the process by which documents would make their way, if they did, from Minister Payne's office to Minister Morrison's office and back again?
What I'd point out with this one, this is actually a brief for the Minister for Social Services for action and for the Minister for Human Services for information. So I would, and you'll have to forgive some of my recollection of the exact processes are confused by time and other subsequent officers. I would have anticipated that a copy of this brief would have gone to the Minister for Social Services office at the same time as it came to ours for information.
Yes, but how does it then get a date stamp if indeed it came to the DHS office at the same time it went to DSS on the signed version?
Yeah, that's, yeah, or I may have delivered it, or someone from the office may have delivered it. I'm sorry, it's been 8 years, I can't recall if, so I've been in 2 portfolios and they've had slightly different processes. So it may be that we took them around, they may have come up in our hard copy delivery bags, came couriers from the department a couple of times a day. We may have taken it around to the Minister for Social Services office.
That is, it may have been stamped by Ms Ridderhoff or the DLO.
And then physically walked around to the Social Services office.
Can I take you to page 10 of 17 of that document? It ends .0046. The title is Systematic Cleanup of Existing Error and Non-Compliance - Operation XXXX2. Item 7, Increased Use of Employment Income Matching. The final dot point, which has been highlighted on this copy, Ms Lees, indicates there may need to be a change of policy to use the ATO data in this way. DSS has also advised legislative change would be needed to implement this initiative, and as a result we have been working with DSS on developing this proposal and will continue to do so. Again, although the time frame was within perhaps a normative time frame, albeit slightly compressed, does the need for legislative change identified in this document have any significance so far as your experience as the Chief of Staff was concerned for that current budget cycle?
Other than noting the need for it, not particularly.
Do you recall whether Minister Payne was concerned at all about the ability to progress the matter or pursue the matter, as the Senior Minister indicated, having the brief note that legislative change was required to do so?
I don't recall any discussion about that issue.
Can you elaborate on that in any way by reference to the nature of the working relationship between Minister Payne and Minister Morrison?
I think it was a very collaborative working arrangement, but as I would say, there is a very big distinction between senior and junior ministers. Senior ministers very much control their portfolio, and there's a hierarchy, I suppose. A junior minister and a relatively new minister with a senior minister is higher in the hierarchy.
Does that mean that upon Minister Morrison's marking of the brief in the way that appears on the first page, that is, that he agreed to the development of a package of new policy proposals as outlined in Attachment A, and that he agreed to the Department of Human Services continuing to work with the Department of Social Services to progress consolidation of additional policy and legislative changes in relation to payment integrity as outlined in Attachment A. Once that indication had been given, it was just a matter of making it happen because it came from the Senior Minister.
Yes, the Senior Minister had made a decision, and the process would have been to do as he'd indicated, which was to pursue that measure.
From the collaborative relationship that you've described, do you recall contact on a regular or semi-regular basis between Minister Payne and Minister Morrison in an informal or formal way?
We had, in sitting weeks, I can't remember if it was weekly or fortnightly, there were portfolio ministers' meetings, which Minister Morrison convened with his. We had, I think, 2 parliamentary secretaries as well as ourselves in the portfolio. So there were regular meetings about the portfolio in that. That's a more formal engagement. I couldn't tell you about the how frequently informal contact would have been made. It wasn't constant. The Senior Minister was quite a busy man, so and they operated in different houses of the Parliament, so the opportunity for those sorts of casual conversations, which quite often happen in Parliament in the chamber, weren't there.
To your observation, was Minister Payne comfortable just picking up the telephone and calling Minister Morrison about issues that affected both departments? That is, without an appointment, without a formal meeting?
I think she would have been comfortable to contact him.
Well, we've moved forward then to Tuesday the 3rd of March behind tab 25 in that bundle, Exhibit 5230. This is an email from Ms Kenning to you, copied to the Deputy Secretary and the email address of Ms Campbell's office. Do you recall, Ms Canning?
Not really.
Is this the first occasion you have been able to identify on which the department provided a draft new policy proposal following Minister Morrison's signing of the executive minute?
I believe so.
Were you aware at this time that the schedule for the Department of Social Services portfolio budget submissions to be considered by the Executive Review Committee was to take place on 18 March 2015?
I'm not sure.
When this document was received by you, do you recall being advised at any point, that is, between 20 February 2015, when Minister Morrison signed the executive minute, and when you first receive a draft of the NPP arising out of that minute, that DHS and DSS had worked together to resolve the question of the need for legislative change?
No, I have not been able to find anything to that effect.
What about after the 3rd of March 2015? Have you identified any point at which you were informed, or it appears Minister Payne was informed, that the resolution of the question for legislative change as between the departments had been resolved?
No.
The last paragraph refers to clearance of this NPP. What does that mean in real terms or practical terms?
It means that the department had drafted a new policy proposal, which they were wanting to submit into the Department of Social Services portfolio budget submission, and they were seeking the Minister's clearance of the content of it.
Is clearance another word for approval?
Yes.
Okay. That is Minister Payne's approval of the content to be forwarded to DSS for their consideration and inclusion in the PBS.
Yes.
And just to confirm, the attachment of the draft, which is described at least in the attachment title of the email as apparently version 8, appears behind tab 26, Exhibit 5231.
Yes.
Thank you. Can I just ask you to take note in this document on page 3 of 6.0129 of the 2 paragraphs above the passage in the centre of the page which has been marked through, the paragraphs commence in addition and the new approach. Do you see that? I'm going to compare it to some formatting changes which occur later and ask you about the Minister's involvement in revisions of the NPP.
Okay.
Thank you. We could turn to tab 27, Exhibit 5232. And just to keep the chronology alive, the email was sent by Ms Canning to you at 8:32 on Tuesday the 3rd of March, and your response is at 8:46, so not too long afterwards. Your question is, do we know yet the financial summary for the compliance package? Please forward the text and NPPs for all savings measures to DSS. The second request first, does that mean that Minister Payne had approved the content to be forwarded to DSS?
I believe so.
Right. Undoubtedly, that would have involved you having a conversation with Minister Payne or forwarding an email.
I haven't been able to find the email, but I would have definitely had a conversation with her about it.
Okay. And your email reflects her approval?
Yes.
And the next step. The financial summary for the compliance package, these are the costings which are developed in respect of a new policy proposal.
Yes, and I think at this stage they weren't worked up properly yet.
In the ordinary course, and I appreciate timeframes get compressed and expanded, but would costings be worked up at the same time as the content in the ordinary course?
No, not always. It's not, I think this was prepared for the exposure draft of the portfolio budget submission. It's not uncommon for the financial tables to be empty in all of those MPPs at that time.
Okay.
It's more about socialising the measure.
And that is making sure that those departments affected, Treasury, Finance, DSS and others, have the opportunity to see the content.
And comment, yes.
Yes. The next email is Exhibit 5233 behind tab 28. It's the response to your costing question. And confirms, as you said, that the version that was provided to you earlier that day was for the purpose of an exposure draft lodgement today. That is on the 3rd.
Yes.
We can turn to tab 29, Exhibit 5234. The two additions to the previous email trail are your request of Ms Canning at 9:24 about small amendments to the MPPs and her response to that.
Yes.
In your experience, was Minister Payne, did she have a high level of attention to detail?
Yes, and she was quite pedantic about language, which is why I was probably trying to preserve the right to amend.
Without holding up the exposure draft process?
That's right.
If you turn to tab 30, please, Ms Lees. We're still on 3 March, but this is another version, it seems, of the MPP forwarded from Ms Canning. It has the number 10 after the title in the attachments, as compared to number 8 earlier that day. And it refers to edits cleared by Melissa, that's the Deputy Secretary, Ms Golightly.
That's right.
And asks you whether you've been able to settle the unclear items in the draft provided with Morrison's office so that this version could be provided to DSS.
Yes.
If I take you to the attachment 5236 and particularly page 3 of 6.
Is that tab 31?
Yes, thank you. You'll see the editing or format change which I identified earlier in the passage just above the redactions in the middle of the page. That's at least some edits that had occurred which are identifiable on the 3rd. Do you recall any additional edits that were made by Minister Payne?
No, I don't.
I take you to tab 32. Exhibit 5237. There are a sequence of additions to the email trail which commenced earlier in the day. Your response to Ms Canning at 2:31 p.m. was no, their advice is to submit as is while they seek further clarification from within their office. Does that reflect that you telephoned or spoke to someone within Minister Morrison's office who conveyed that?
Yes, it does.
And I take it you can say that, one, because of the content that's
Yes.
come from the office, and two, because you can't locate an email which says that.
No, I can't locate an email.
Do you know who you would have spoken to or who you did speak to?
Well, I believe it'd be one of two people.
Yes.
It would either be Charles Wann, who was, I think, senior advisor in Minister Morrison's office at the time,
Yes.
or a lady called Danielle Donegan, who was also helping with budget in that office at that time. But I think more likely Charles.
Ms Canning responds to confirm that you were happy for her to provide to DSS, removing the highlighted passages which were still under consideration by Minister Morrison. And you also communicated that you had reminded, I assume, Minister Morrison's office that the MPP currently includes those items, but they could be removed if that's what the Minister preferred.
Yes, so we didn't remove the paragraphs, we just removed the yellow highlight from them. And I think there's a subsequent email that I sent to Mr Wann,
Behind tab 33?
behind 33, in which I just reminded him that we have put in proposals that we hadn't yet had the opportunity to discuss with Minister Morrison, but the timing hadn't allowed for that.
Yes. And if we go to that email behind, which is Exhibit 2563, tab 33, this is your email from Mr Wann on the same date, 2:50 in the afternoon, which attaches that version 10 according to the attachment title and the background to the provision of the NPP.
Yes.
You refer there to a discussion earlier that day or in the morning of the same day. Do you have any record or recollection of what was discussed?
No, but I can only assume from it, it was the reference to the previous email to Emily where I said the office has advised to go ahead. I probably chased him about what to do.
Okay. And to continue the sequence, behind tab 35, you see Mr Wann's response, Exhibit 5238, at almost 8:30 that night. We'll decide treatment in the morning. Is that the reference to the fact that the Minister would decide whether he wanted those measures included or not?
That's what I understand that to mean,
That's what
yes.
you understand. Thank you. Can I take you to tab 41, Ms Lees? You followed up on Friday the 6th of March 2015, Exhibit 5247, about those three aspects which had to be determined by the Minister for inclusion or not.
Yes.
And his response is Exhibit 5248 on the same day behind tab 42. Which indicated to you, I take it, that the Minister or the Minister's office or both were reviewing the draft NPP perhaps over the weekend for a response to you early the following week.
I certainly interpreted that I had not yet had the opportunity to have that discussion. with Minister Morrison.
If you go to tab 43, you are not a party to the email, but it records some events on the following day, Saturday, 7 March 2015, which reflect the Minister's office had comments on several of the NPPs and was seeking some additional information which had minor editorial changes suggested by the Minister. Now, do you know whether that is Minister Morrison's office or Minister Payne's office?
I'm not completely sure. I assumed when I read this it was our office. Largely because it talks about the Whippet developments, which were our portfolio responsibility.
That is the DHS portfolio responsibility.
Yes, that refers to the welfare payment infrastructure transformation, which was reworking the welfare payment computer system.
Can I take you to the attachment at tab 44, exhibit 5250? Some changes noted as requested by the Minister's office are recorded on this document. I take you to page 2 of 5.5968. You'll see some perfection of language under the heading policy case. And further down.
The redacted one?
No, the comment on the side, MP1, change requested by the Minister, and MP2, changes requested by the Minister.
Yes, but I can't see those.
Oh, it's redacted in yours,
Yep.
right. At least in respect of the first,
Yes.
does that tend to confirm what you thought was the case when you read it, that the reference to the Minister's office in the email which attached this document was a reference to Minister Payne?
Yes, because she was very careful about the proper use of the English language.
And if you move to the page ending 5971, you can see that amendments have been made under the heading legislation here to the boxes marked 2.0 and 2.1.
Yes.
Which reflect that by this point in time, the Australian Government solicitor had advised on constitutional and legislative authority risk.
Yes.
That is, by 7 March 2015, that had occurred. Can I take you to tab 45A, exhibit 5253? Ms Lees, this is an email from Ms Canning to you, copied to the Secretary, Katherine Campbell, Tuesday, 10 March 2015.
Sorry, Mr Gregory, can I check the tab reference? Because I've got another version of the MPP there.
At 45A?
At 45A, that's what I've got. Not an email.
Can you go to 40, is there a 45B in yours?
No.
Right.
I have a 45 and a 45A.
Is 45 another version of the NPP?
Yes.
Looks like you might have doubled up. Sorry about that. You'll have to go off the screen.
If you go behind 45, you don't get 45B? I mean 45 and 46?
I can provide a hard copy if that's of assistance.
Thank you.
No, I've got nothing else.
Thank you. The content of the email reflects a communication from the Department of Social Services on the same date that the next version of the Social Services portfolio budget submission, is being submitted to Minister Morrison on Thursday morning, which would make that the 12th of March 2015. And there are various edits to reflect comments on the exposure draft. The final substantive paragraph refers to Minister Payne's clearance on the revised MPPs tomorrow afternoon. The reference there, I take it from your earlier evidence, is that any revisions which had occurred between the 3rd of March and the 10th of March in respect of the new policy proposals were to be approved by Minister Payne as part of that process before being resubmitted to the Senior Minister.
That's right.
Does that indicate to you that that was the first occasion that the Minister Morrison would have been provided with the portfolio budget submission, or are you unable to say?
I'm unable to say definitively, but I noticed this says the next version. I assume he would have seen a previous version.
Right.
Noting that he would have cleared the exposure draft version, typically. Typically a minister would clear an exposure draft version before it was released to other ministers.
Is it also typical that before it reaches the minister, even at the exposure draft stage, that a secretary or deputy secretary would clear the content?
They would typically clear the content before it came to the minister's office, yes.
So taking this sequence, 3 March 2015 is the first occasion where the draft is provided through you to Mr. Wann. Do you expect that the department, that is someone at DHS, also provided a version of the NPP on or about that date to someone in DSS for that clearance process?
No, I think it would have been cleared internally in DHS and sent to us to send to the minister's office. They may well have shared a version of it internally. I can't speak for that. It's quite common for agencies to circulate various drafts on a no surprises basis.
Thank you. Can I take you to tab 47? In your statement at paragraph 65A, you describe this email as one which you forwarded by which you forwarded comments on the exposure draft of the MPP to the Minister. The Minister, of course, Exhibit 5255. And that reflects that it wasn't just this particular NPP which had been generated in draft and sent to your office and from you to Mr. Wann, but the whole of the exposure draft of the DSS portfolio budget submission, which was included in this email. Is that right?
No, my understanding of this email is that we were receiving a copy of the comments that had come back in from other agencies about the previous version of the exposure draft version that was sent out before that email that you just referenced. So these are just the comments from each of those portfolios on the MPP.
And the portfolios are Prime Minister and Cabinet, Treasury, Department of Finance and the Department of Employment. Have I missed any?
I'm just looking at the acronyms there myself. PM and Prime Minister and Cabinet, Treasury, Department of Finance, Department of Employment.
Thank you. Can I just clarify with you one point, Ms Lees? Do you have your statement there?
Yes.
And paragraph 65B. The email to which we just referred was the subject of paragraph 65A.
I believe so.
65B relates to another email which you located in preparing your statement, which indicated that, which reflected the contents of a telephone call made by Ms Golightly to you on the same date about feedback in respect of the exposure draft.
Yes, from memory, there was a comment made by the Department of Prime Minister and Cabinet that didn't make a lot of sense, and the department, Melissa Golightly, had contacted them to talk that through.
Thank you. Can I take you to tab 50C, exhibit 5258. The relevant attachment is the NPP integrity, you see that?
Yes.
And as I read it, you have made comments on this one, that is a couple of small edits in the compliance one that you would make for, and you were providing those to the Minister for her consideration.
Yes.
The notation, if we go to the attachment behind tab 50D, is exhibit 5259. The edit appears at page 3 of 8 in the handwriting in the first paragraph.
I think that's me.
That's you? All right, thank you.
There was a poor grammar again.
Was that the only edit that you proposed to make?
I think so. I knew it would irritate the minister.
On the same day, if we go to tab 50E, the sequence of events appears to be that Minister Payne was Exhibit 5260 responded to an email from you at 4:33 p.m, which attached revised ERCs, and it seems to communicate that the Minister, 5260, CTH.400.0399.0052_R.
Mr Gregory, again, I think I've got the wrong tab.
The documents on the screen, it looks nothing like the one that you've got behind tab 50E.
I'm at the wrong tab.
Oh, sorry.
Sorry. I'll look on the screen. I don't have a 50E.
The NPPs have been redacted, which indicates they may not be the integrity NPP, but at least by this point, Wednesday 11 March 2015, you were aware that the Expenditure Review Committee was scheduled for 25 March in respect of the Department of Social Services portfolio budget submissions consideration, yes. And it appears that the Minister was very responsive to the emails that you were sending her in respect of the portfolio budget submission NPPs relevant to her department.
Yes.
To be clear about the sequence, behind tab 50C was the email, I think, Exhibit 5258, by which you forwarded the integrity NPP at 5:05, and these other NPPs were forwarded at a different time, but the response appears to be in respect of the attachments to the second.
50C is a subsequent email following up on the email that you have on the screen that said compliance. If you see 3/4 of the way down the screen, that big redacted box, compliance MPP, and the other one are on the way. This is that subsequent email.
Thank you. I take you to tab 50B. Exhibit 5257. Although this email did not involve you, it records an exchange between Ms Canning and the Secretary, Ms Campbell, that the DHS NPPs have been signed off by Minister Payne and are now with DSS.
Yes.
That accords with the sequence of events so far as you've been able to ascertain them.
I'd assume so. Those previous emails indicated the Minister was travelling, that she was looking at her emails and that she was communicating with me.
And the communication may well have been by telephone in terms of the approval of the content.
Yes.
Ms Lees, can I take you to tab 52A, Exhibit 5263? In paragraph 66 of your statement, you say, on review of the materials available to me, I have not been able to locate a written record of Minister Payne clearing the NPP. The NPP, I think, to which you refer is this last version, or the version which appears at 12 March 2015.
Yes.
Does that mean, does your statement about the absence of a written record indicate that Minister Payne approved the final version in a telephone call to you?
I believe so.
At paragraph 57 of your statement, you describe the usual practice if Minister Payne was required to attend a meeting of the Expenditure Review Committee, including preparation of a briefing folder and a pre-brief with officials from the department. Can I take you to tab 52C, Exhibit 2182? By this point in time, matters had progressed to Wednesday, 18 March 2015, that is 1 week prior to the consideration by the Expenditure Review Committee of the DSS portfolio budget submission. And if I could ask that the version _R be brought up, please. And Ms Lees, the email doesn't appear to involve you. That is, you're not a party to it, but it refers to you this morning, refers to you in a discussion that morning, it seems, with Ms Golightly. And what is attributed to you in a conversation is that the Minister is probably not across the BI MPP as much as she may be for some of the others. So we will need to do a detailed briefing for her on all the items in the brief. But I agree with you, particularly on the PAYG one. Pausing there, BI, did you understand that to mean business integrity?
I do when I look at that, yes.
Yes. And the PAYG measure is a reference to the draft of the NPP which we've been looking at.
I believe so.
Have you been able to locate a briefing, detailed or otherwise, that was prepared by the department for the Minister?
No.
What do you make of that?
I think this reflects a conversation that I would have had with the department about organising the pre-briefing meeting and about where they may want to focus their time and written material. Bearing in mind what the department typically produces for an ERC meeting is response to the finance green, which is the Department of Finance's comment on that proposal, as well as any other comments we've had raised throughout the process of exposure and coordination comments against the portfolio budget submission. In regards to the Minister not being across that one as much, I think what I'd be reflecting there is that from memory there are 3 or 4 new policy proposals, particularly relating to human services, which were in contrast to the strengthening the integrity of the welfare system, NPP, relatively straightforward one measure MPPs, whereas this one had many components.
Right. You were able to locate, I think, diary entries which reflected meetings on 25 March 2015, which appeared to be pre-ERC briefings.
Yes.
Can you recall who was noted as attending those?
I think it was the secretary, myself, Melissa Golightly, and Mark Whitnell. And I think there may have been another couple of deputy secretaries because there were 4 NPPs, but those are the ones who had responsibility for this MPP.
Okay. Can I take you to Exhibit 5265. Should be behind tab 53, Ms. Lees. The email appears to be amongst persons within DSS.
Not my 53. Sorry.
Maybe it's 52.
I've got it at 52, but I don't know that we match.
I've got an MPP at 52.
There is a document on the screen which appears to be among people, that is an email between persons at DSS, Wednesday 18 March 2015, and the attachment is the coordination comments. Front end and back end. Might be 52D. Do you have a 52D?
Got it.
Thank you.
Is it Exhibit 2565
Yes.
as opposed to 26, the other one you said? DSS 7001 0001 0002.
Yes. The version at this stage of the NPP process has reached the coordination comments stage, which follows the exposure draft comments stage. I know that
Yes.
you're nodding, but yes.
Yes, sorry.
Thank
Yes.
you. And reflects very closely, if not entirely, the document which was placed before the ERC in the portfolio budget submission.
I'd assume so. I wouldn't have got this email.
All right. The Exhibit 2507, I hope is behind tab 59 in your bundle, Ms. Lees. I'm not sure that it's the updated version. The title of the document refers to the ERC attendance record for 25 March 2015, and under the heading Co-optees - Chief of Staff and Secretary. Given a hard copy, perhaps if that could be taken to the witness. Thank you.
Thank you.
I also have a copy for the Commissioner, sorry.
Yeah, I've got it, thanks.
I'm not sure if the Commission's copy is...
Oh, okay.
is
I don't have the fully redacted, the one that's been further redacted, unredacted, I should say.
Oh, it's got one.
Oh, it now appears on the screen. PMC.001.0054.001. Commissioner, I was advised during the lunch break that the attempts had been made, and it is now clear that they were successful to unredact Ms Lee's name
I've got you.
on the document in the centre column. And Ms Lees, that attendance record conveys that you were present for the ERC consideration of item 5A only, together with Minister Payne and Secretary Campbell on that date.
Yes.
Do you recall it?
No.
Can I take you to tab 61? Exhibit 2507A, PMC.0001.0010.9004_R. It confirms that item 5A for the ERC second revised business list of Wednesday 25 March 2015 is the portfolio budget submission for the Department of Social Services and the finance green brief which refers, where Mr Morrison, Senator Payne and Senator Fifield were in attendance. You can see that?
Yes.
Given the history of the development of the NPP in respect of the PAYG measure being an initiative of DHS, you're not surprised by the attendance of Minister Payne and the record of yourself attending?
No.
And does it reflect the fact that in preparation for Minister Payne's attendance, steps would have been taken according to the usual practice to provide a briefing to her on the NPP in the manner or in the content that you described earlier?
Yes, for that and the other few MPPs that she had direct involvement with.
Was it usual practice then for, in this scenario, where DSS had potentially a larger number of NPPs as part of its portfolio budget submission, that DSS would prepare briefings for Minister Payne on those?
My recollection is that she wouldn't necessarily stay for the entirety of the portfolio budget submission conversation. She would stay for those items that she was directly responsible for.
Yes.
But I can't recall this meeting to know if that's how it happened. Sometimes it moves so fast in the discussion that ministers don't move in and out of the room, but...
As I understand the tenor of what your statement conveys, it's likely that the briefings given to Minister Payne by either department were those given to her by DHS in respect of the policy proposals generated by DHS.
Yes.
Of which there were...
I would doubt very much we would get... Minister Payne would be provided with points from DSS. That doesn't mean that officials may not have talked about or shared content in creation of those talking points.
But naturally, Minister Payne's focus would be upon those policy proposals generated by DHS.
That's right.
And her briefings would reflect that.
Yes.
Thank you, Commissioner.
In that 2 or 3 weeks between the signing of the executive minute and the preparation of the NPP, do you recall hearing more of the DHS and DSS working together on the policy and legislative changes?
Not specifically, Commissioner, no.
Okay, would you expect that to be reported to the Minister's office if it were occurring, given that it
Not
was indicated?
typically, unless there was a problem. That's usually when matters get raised. As a matter of course, departments, particularly in this portfolio where there's a portfolio owner and a service delivery agency, work together on details of things all the time. So there wouldn't, unless something exceptional happened, wouldn't necessarily be comment back up to the office.
Okay, you just assume it was ticking along.
Exactly.
would you?
Exactly, Commissioner.
Thank you. Anything arising out of that, Mr Gregory?
No, thank you, Commissioner.
All right, Ms Hogan-Doran?
Nothing arising, Commissioner.
I don't think Mr Andriotidis was seeking to cross-examine it, so thank you. Do you want Ms Lees excused?
I do, thank you.
Thanks, Ms Lees. You're excused.
Commissioner, through your associate, could I get that piece of paper back that was provided? Thank you.
The next witness is Mr Charles Wann.
Thank you. Mr Wann, will you take an oath or an affirmation?
Affirmation.
Okay, would you stand, please?
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Take a seat. Yes, Mr Gregory.
Thank you, Commissioner. Can you tell the Commission your full name, please?
Charles Samuel Wann.
Mr Wann, you were served with a notice to give a statement and produce documents NTG-0129 dated 16 December 2022.
That's correct.
And you produced a statement in response dated 18 January 2023, which was updated by you and completed on 15 February 2023.
That's correct.
Thank you. There is a bundle of documents over to your far right. We might have that brought to you in a moment if we need to. But you were the Chief of Staff for the Minister for Social Services, Mr Scott Morrison, for a period of time in at least very late 2014 and 2015.
Chief of Staff. No, I was Chief of Staff from around about the middle of March through to the end of September, when he shifted over to the Treasurer role.
Well, thank you, yes.
So I was Senior Advisor from when he first became Minister for Social Services in late December through to mid-March.
The updates that you provided to your statement in February reflected that you had, after completing your statement, located some notebooks.
Yes, that's right. That's right.
And if we might go to those, your statement is Exhibit 5206, Mr Wann. It should appear behind tab 4C in the bundle before you.
That's right.
And to be clear, what you did was add the supplementary statement by reference to your notebooks at the start and then attach your first statement, so there was a single complete document.
That's correct.
Thank you. In paragraph 6A, you refer to an entry which reflects a meeting between Ms Campbell, the Secretary of the Department of Human Services, and the Minister, that's Minister Morrison, on 30 December 2014.
That's correct.
And the notebook entry is Annexure A to that statement. And if we could go to Annexure A in the statement on the screen, please. Which I think is the third page of the document. The document is CWA.9999.0001.0005_R. My version, at least, doesn't have page numbers marked on it. But that was it. Thank you. In paragraph 6A of your statement, Mr. Wann, you were able to say this reflected a meeting on 30 December 2014. How were you able to identify that date?
There was a note entry on the previous page of a meeting between the Minister with the Secretary for Social Services, Finn Pratt, accompanied by the Deputy Secretary for Childcare, Jackie Wilson, along with the Chief of Staff, and Brandon Baker, Brendan Tegg, and myself. In the notes that I took for that meeting, I had the participants and the dates recorded along the top. And then this was the next page, which was a meeting with the head of the Department of Human Services, Katherine Campbell.
And the date on the previous page, was it the same?
Was the 30th of December.
And so it revealed to you that Minister Morrison met with the Secretary of DSS, Mr Pratt, and others from the department before then meeting with Ms Campbell on the same day.
That's correct, yep.
Right. The pink marking which you've identified here was added by you recently.
That's correct.
That is, it wasn't part of the markings that you made at the time you made the note?
No.
Right. DHS-Katherine, that's Catherine, that's a reference to the Secretary, Ms Campbell.
Yes.
And you've identified compliance-JSA check going to, is that interview?
It could be that.
Could it be anything else?
That's a good attempt at what it might be.
Okay. It might be best then if you just read out what you've highlighted in pink.
Okay. So compliance, JSA, which I take to be Job Services Australia, check going to interview. Then the next stop point, 350 people, mostly in-house, not field. I assume that's reference to in-house compliance capacity, as in compliance officers that are situated in DHS as opposed to out in their national office rather than out in state territory offices, but I could be wrong on that. Then compliance plan and outcomes, ICT, then going further down, 1.1 billion over 7 years, pay off within 4 years. I'm assuming, looking back on it, that refers to the cost of a new system, ICT system. And then further down, there's section challenges, the IT, I presume that refers to the IT system referred to above, non-compliance, and then over the page, under the heading Most Excited, MyGov website, move everyone online, and then further down, what appears to perhaps be a summary of the discussion, integrity package, IT systems.
Just returning to the 1.1 billion over 7 years, pay off within 4 years. How does an IT system get paid off in that context?
The mysterious rules of government. The cost, I just looking at this, it would progressively be incurred over a 7-year period, totaling 1.1 billion. The expectation likely would be that that needs to be offset as according to the budget rules, and there appears to be a suggestion, I presume by Ms. Campbell, that that could be paid off within 4 years.
When you're talking about budget offsets according to budget rules, are you referring to the requirement at this point in time for expenditure to be approved? There had to be an equal or greater savings or offset measure?
That is the rules currently, and it's the rules back at the... It would have been the rules back then as well.
Do you recall from the meeting whether Ms Campbell indicated that how that measure was going to be paid off within 4 years, that is the offset?
I don't actually recall the meeting at all. And all I can offer up is my interpretation of what's on the page there.
Thank you. Sticking with an X-ray at the bottom of the page towards the centre, there is a section which has not been highlighted in pink. Are you able to decipher your note there?
Is that the section linked to McClure?
No, right at the bottom of the page.
Oh, right at the bottom of the page, sorry.
Towards the middle, that's it.
Oh, there, okay. Policy, reliance on payments, entitlements-based.
And do you recall whether that was related to the integrity package that was referred to, or the compliance package which you've highlighted above?
I don't know.
Thank you. Paragraph 6B of your statement refers to a meeting in late January 2015 on welfare reform where participants are not recorded, but integrity package is referenced amongst a list of other topics, and it's contained on Annexure B. If it's possible to bring up Annexure B, but while that happens, can I ask you again, Mr. Wann, how you were able to identify this entry was for late January?
I looked at the meetings before that had dates, and the next meeting afterward that had a date, and this fell in between and the period was located to late January.
Before I move on, were you able to identify in the meeting between Minister Morrison and Secretary Pratt on 30 December 2014 any reference to compliance or savings measures?
No.
Okay. The reference at the top, welfare reform, does that, on your recollection, relate to compliance or integrity or something else?
No. Welfare reform in this context would have been in relation to the McClure Review and the recommendations coming out of the McClure Review. None of that that I can recall went to anything to do with compliance.
The highlight at the bottom of the page, integrity package, what are you able to say about the relevance of that highlighted passage?
I don't recall what the reference to integrity package referred to at all. All I can work out is that the bit in brackets beneath it refers to carer's visa, and I can only surmise that had something to do with integrity around carers policy as it related to social security legislation.
Thank you, Mr. Wann. The next reference of a diary entry that you located which may have relevance is Annexure C, and you describe it in paragraph 6C as around late January or early February 2015, before 10 February 2015. Do I take it then it came after the previous entry but before an entry marked 10 February?
That's correct.
And you're not able to be any more precise in terms of dates?
That's correct.
And what about attendees?
I didn't record any attendees.
Does the content of your note indicate who might have been present?
I suspected, look, I really don't know, but I suspect it might have been maybe Serena Wilson and Kath Halbert, but that'd be guessing.
Is there something to indicate why you say that?
Because the nature of the subject matter goes to matters around the design of payments. For example, waiting periods. I presume WFD refers to work for the dole, and then it goes into various settings around that. Option 2 looks at the job service compliance framework, but it goes into matters around mutual obligation, so they're matters that would more likely sit in consideration of design of programs rather than the delivery of or enforcement of the programs.
The box on the left page towards the centre, is that a reference to the makeup of the Senate?
It looks like the makeup of the crossbenchers.
Sorry, the makeup of the crossbenchers.
Yes, yeah.
And on that topic, do you recall there was acute awareness on the part of Minister Morrison about the difficulty of passing legislation through the Senate because of the makeup of the crossbenchers?
it was, my recollection was it was always a consideration how you would get legislative change through the Parliament, and consideration of the posture of crossbenchers, of the Greens, of Labor was always very important in that respect. It certainly didn't influence whether he was prepared. It didn't make him shy in bringing forward legislative change, and there's some very telling examples of his time in the social services portfolio of bringing forward very difficult legislation and getting it passed through Parliament.
The highlighting that you've made, what does that communicate, or what does that reflect?
It reflects my my very brief contemporary view of what might be relevant or not. And in this issue, on this page, the view I came to was this related to savings, but not in relation to data matching. It was more about participation, but provided it for completeness.
Okay. Starting in the top left corner, HS has written to PM. Who's HS? Or what is HS?
I don't know.
20 Feb is circled with an arrow towards a decision. Do you know what that relates to?
I don't know.
Moving on to the other page, there's a heading budget strategy about a third of the way down.
Mm-hmm.
Perhaps if you could read.
Oh, okay, sorry.
There.
Oh, all the items?
Thank you.
Budget strategy. I can't make it out. ACOS, deeming, Scullion, follow up with stakeholders. I'm not sure what that refers to. McClure, I think? No, I'm not sure. And fraud/strategy, Payne.
Is that a reference to Minister Payne, the Minister of DHS?
I suspect so.
Continuing with the annexures, I should say, do you recall anything about that topic of fraud/strategy, Payne?
No.
And what have you written beside the reference to the crossbenchers in the Senate?
Against each of them?
Yes.
Madigan, Spend, Day. I can't make out. Lane Home, Save, Xenophon, Spend, Newell, ? Pup, ? Jackie Lambie, Cross.
What's the cross signify there in the context of save or spend allocations against crossbenchers?
I suspect that refers to, look, I don't exactly recall, but looking back on it, it may refer to Jackie Lambie not being in consideration and discussion around this package.
In paragraph 6D, you refer to a meeting with Ms Wilson, Ty, TYE, and Ms Halbert, 19 February 2015, which is referred to in Annexure D. And again, you have highlighted Serena/Ty/Kath 19/2, that's the 19th of February.
Yes.
And the integrity package is the second dot point on the second page that you've highlighted. what have you noted beside it in the pink highlighter?
It was first referenced 19th of the 2nd to the integrity package. Now, I was going through this quite quickly in the first instance, so upon gathering all the different references, that was then reflected in my final statement.
I see. But what have you written there? Lot, not, or?
No, first reference.
Oh, it's first, 1ST.
So it's, yeah,
REF.
first and then REF.
I see, thank you. And do you recall who Ty was?
No.
Mr Whitecross is mentioned there further down the page.
Yes.
Is what is written below him, the word, is it supported?
Yes.
And to whom is that attributed? Is that Mr Whitecross or is that someone else?
It appears to be a meeting, well, again, I don't recall, but just reading it, it appears to be a meeting with Mr Whitecross. I don't know what supported refers to, apart from the normal meaning of the word. I don't know what it refers to in relation to those items listed below.
Thank you. And in paragraph 6E of your statement, you refer to the record in your diary at Exhibit E, which is described as a telephone conversation note with Mr Dilly on 4 May 2015, noting, quote, savings dash anything more, end quote. That may be a reference to correspondence to the Minister for Finance dated 28 April 2015 as referred to in your main statement.
Yes.
And anything more, does that mean any more information or any more savings? What can you say?
I'm sorry, I don't recall.
Just while you've got those annexures, can I get you just to flick back to annexure A?
A, Commissioner, yeah?
And just tell me if that's Mark Withnell's name on the third line and what's below it.
Mark Wicknell, AFP. Looks like organised and non-organised.
Okay, can you shed any more light?
If it's in relation, well, again, just looking back on it, it looks like it might, because it's in relation to AFP, it might be linked to perhaps organised crime.
And non-organised?
And non-organised non-compliance.
Okay, do you recall talk of something called Task Force Integrity?
No.
Okay, thank you.
Are you able to say, Mr Wann, at the bottom of the page where you write challenges and underneath it IT and then non-compliance, is the policy reliance on payment and entitlements based a reference to challenges?
It could well do.
Now, Mr Wann, I should have indicated to you earlier that you've identified a typographical error at paragraph 27A of your statement, which refers to a particular date as 30 December 2015, when that should be 30 December 2014.
That's correct.
As the date of the diary entry recording the meeting between Ms Campbell and Minister Morris.
That's correct.
Save for that correction are the contents of your supplementary statement and first statement as they are combined in Exhibit 5206. True and correct?
I think there was one other correction, a minor typo, and I'm just trying to recall what it was.
It's been covered by a redaction, so you don't need to worry about that.
Okay, thank you.
So the answer was true and correct?
That's right.
Thank you.
Thank you, Commissioner. Mr. Wann, can I take you to tab 24 in the bundle? This is an executive minute prepared by the Department of Human Services to the Minister for Social Services for action and the Minister for Human Services for information. Exhibit 2669. Tab 24.
Tab 24 is an email.
Is that email B15125 in the title?
Oh, sorry. No, sorry, behind 24 is the executive memorandum. That's it there, yeah.
Mr. Wann, there are two dates which appear on the face of this document. The first contained in the stamp in the top right corner, received 12 February 2015, DHS DLO, and the second is the date that the document was signed by Minister Morrison, 20 February 2015. What can you recall about the process which might explain how Departmental Liaison Officer stamped this document in the DHS Minister's office on 12 February, but it was signed by Minister Morrison on the 20th of February?
I don't recall, but I suspect the submission would have travelled from the Department of Human Services through to the Human Services Minister's office through their PDMS, and then was printed and then walked around to the Minister for Social Services office for entry into our system and then distribution.
If I take you to page 10 of 17 of that document, it is .0046. Item 7 is the systematic cleanup of existing error and non-compliance - Operation XXX2. You can see some highlighting on that page. From your recollection, was the Minister in the practice of highlighting matters which were of relevance or importance in a particular document?
I don't recall.
What about underlining?
I don't recall with certainty.
Is it likely these markings were made by the Minister rather than any other person in the office?
I couldn't be certain.
No, but is it likely? For example, were you in the practice of highlighting and underlining these documents to the Minister?
Certainly my usual practice was I would provide advice to the Minister on submissions that I received to provide advice to him on a template, and that would be included in the folder that had the original submission, and that would be given to Minister Morrison for his consideration. Other advisors and the Chief of Staff at the time had their own way of managing that, and I couldn't speak for their approaches because I didn't see everything that they looked at and then forwarded on for Minister Morrison's consideration.
When you provided policy advice in respect of something like this to the Minister and you put your advice into a template, What record was kept of those templates and that advice?
They were destroyed after the submission was signed and then returned to the department.
Do you recall what your advice was in respect of this proposal?
I actually don't recall seeing this proposal at all, this document at all.
Who was the Chief of Staff at this point in time?
And Brandon Baker?
And the advice that you provided on a template, was that handwritten or computer generated?
Handwritten is my recollection. In terms of other, so there would have been the Chief of Staff who may or may not have seen this, but there were other advisors as well that may have seen this.
Okay. The reference in the last dot point is the advice of the department that legislative change would be needed to implement the initiative. Between this date, that is 20 February 2015, when it was signed by the Minister, and its development as a new policy proposal considered by the Expenditure Review Committee on 25 March 2015, were you aware at any point of advice that changed that position from the department?
No.
Do you recall if you ever discussed with the Minister the question of whether legislative change, how legislative change would be achieved in respect of this measure?
I don't recall.
Undoubtedly, it would have been a policy consideration in terms of your advice.
Sorry, can you...
If a measure such as this required legislative change, that's something you were likely to advise the Minister about in terms of your position.
If in any policy, if legislation was required, it would have been advised to the Minister as part of any departmental advice.
Yes.
And then what's the Minister do about following up on that?
The Minister would, if he was advised that legislative change was required in any submission, for example, the one I'm familiar with is aged care, he would work the policy up into a position which he thought would have been able to pass through Parliament, taking into account the policy objective that he was trying to achieve.
Right. Doesn't he need to know what kind of legislation will be necessary?
Absolutely. So, yes, Commissioner, in the context of, again, aged care, he spent extensive meetings with the department working through what the policy position would be, and then subsequently coming to a position on that. He worked through how to negotiate that through Parliament. Those policy positions, once they were agreed by the Expenditure Review Committee and then Cabinet and became a decision of government, would then enter into a legislative change program. And the legislative aspects of that would be worked through by the department.
All right. What about in the position here where we see in the executive minute that legislative and policy change will be needed? And then we get to the point of the NPP where there's no indication of legislative change. What would you anticipate would happen about discovering how it is that there's no need for legislative change?
Commissioner, can I take it a step back in relation to this document here?
Yes.
Looking at this document now, and seeing the phrase, as a result, we have been working with DSS on developing this proposal and will continue to do so. My interpretation of that as a public servant is there'd be a number of potential outcomes as a result of that ongoing work. The two departments would continue to work with each other, and they'd either come to a view that the design that was being positioned required legislative change, or the design actually didn't require legislative change, or that the design needed to change as presented here so that it wouldn't require legislative change. So there's a number of potential options working through, which seems to me
Okay, you want
envisaging
to
that.
know presumably which one had been landed on and why?
When you come to the MPP, it looks like there's a settled position, and you would expect that two departments would come, that there would not be an MPP coming forward to administer a final MPP cleared by secretaries that that was not a settled position on the design of the policy and the legislative underpinning.
All right.
Given the content of the page before you, of the three options you described, is it the case that the settled position, as you describe it, had to be that the design of the process had changed?
Looking at the MPP?
Yes.
Looking at the MPP, it is very clear that there would be no changes to... do you have the MPP there? I could.
It is behind tab 34.
Because the words are important. So on page 3 of the MPP.
Yes, Exhibit 2564. This is the first draft forwarded to you by Ms. Lees on 3 March 2015.
I'm looking under 34 and it's DSS 7000 0010980.
That's it, but if you go to tab 33, you'll see its attachment, just the previous tab. See, it's an attachment to an email sent by Ms. Lees.
Oh, okay, yes,
3 March
yes.
2015, yes.
So it's the first version, yep.
Forwarded to you from DHS.
That's right,
Yes.
that's right, that's correct.
All right, yes, and if you go to page .0980, which is 3 of 6, I think this is the page to which you intended to refer.
That's right. So the MPP actually reflects largely the content in terms of the topics covered quite closely. This page refers to the, I think it's option 7.
Yes.
And those 2 dot points, and in particular the first dot point with the 2 sub-dot points, reflect the intent as delivered under this MPP. The first dot point goes to the provision of information early and providing the opportunity for a recipient to correct the record. The second dot point makes it very clear that the new approach will not change how income is assessed or overpayments are calculated. That effectively is saying that the inherent policy position remains unchanged. And if the inherent policy intent has remained the same, then those 3 options that I mentioned, the one they seem to have settled on was no change, therefore no legislation change required.
The problem is you can't really spot what actually is different between that and the executive minute. In other words, what's brought out about this position?
The big difference is that single sentence. And I would say,
You can say it, but the trouble is, how can you look at the executive minute and then at this NPP and say, well, that makes sense. It was required then, but it's not required now.
If you go back to the executive minute, Commissioner.
Yes.
Perhaps if Exhibit 2669 could be placed on the screen beside Exhibit 2564.
And there's a few references in that executive minute that are important.
And page,
Well, page 10 is the one that describes the employment income matching initiative.
But Commissioner, I'd just like to go to a bit before that. There's a few very important points in the minute. The first one, I think it's paragraph after this, paragraph 4, so the next page. So it says the 2 operations could be undertaken under existing arrangements, but would be significantly strengthened if the suggested policy and legislative changes were adopted. So it
where are we
envisages.
looking here? I've lost you. Which
Sorry,
paragraph?
it's paragraph 4. Sorry, Commissioner, and it's the first sentence in paragraph 4. So even in this executive minute, it does envisage 2 options. Under existing arrangements, but it would be significantly strengthened if the suggested policy and legislative changes were adopted. If you then go to, if I could just see the rest of the page. There is a section, and then if you go to attachment B, where it talks about the second main option around I've forgotten the words, but fixing up corrections or so detecting and investigating welfare fraud, that mainly refers, I think, to the task force. So if you keep going.
You probably want page 10, don't you, which is 7, increased use of employment income matching. That's the initiative we're talking about.
That's the initiative, but the background in the next, in attachment B, provides important context.
So
page 14 of 17, you think? Sorry, pages 13 and 14 of 17.
Okay, directing and correcting customer error in welfare programs. That's correct. So if you look at paragraph 14, it talks about the various constraints in correcting customer error, and it talks about legislative policy and ICT systems. Paragraph 15 then goes into more detail around the ICT systems. And then paragraph 16 and 17 really goes to the more aggressive option, I think that DHS envisaged, which would require policy change. And then paragraphs 18...
And legislative change.
And legislative
because it talks
change,
about legislative
yes,
and policy constraints.
That's correct.
Due to the need to apply income fortnightly to determine overpayments.
That's exactly right, Commissioner. So
because income is determined annually by the ATO, so it's fairly clear that if you're using ATO information, you have those legislative and policy constraints.
Exactly. That's exactly right, Commissioner. So that's 16 and 17 prescribe different way of doing things. Paragraphs 18 to 21 go through a different approach, which is really about influencing behaviour by providing information to a customer or a recipient, information on the income that is on file, and there's been trials on this, I think it suggests. And then by implementing this sort of approach, the DHS is suggesting that there'd be a reduction in non-compliance and better entry of accurate information. So it's kind of, in my view, reading this now, it's presenting a couple of options. Then when you go to the MPP...
Yeah, but can I stop you? Those paragraphs are about debt prevention. This is to ensure that people, if you give them the information we already have, it makes it less likely that they'll underdeclare their earnings.
That's exactly right.
But surely it wasn't thought that that's what the NPP was about?
Well, if you go to the NPP, again, this information, so it's going to the first stop point.
Exhibit 2564.
This information will be presented to the customer via their online account and require the customer to either confirm the information is correct or provide updated information. This puts the obligation on the customer to ensure their record is correct and will remove the significant regulatory burden for small business that is required under the current approach. It then goes on to say the new approach will not change how income is assessed or overpayments calculated.
Right. My point to you was, how does that sentence stand with a description of a process by which there's a clean-up of these 866,857 customers, providing debt, some amount in debt and savings based on ATO information that would give you any satisfaction that it was a different proposal?
Well, if you go to the costings in the green brief, which is another document you have on file, it goes to the staffing required. And I think it's in the executive memorandum. It might have been either in attachment A or attachment B. It gives two options around the staffing. It says under existing arrangements, you'd need maybe 1,000 a year over 3 years to give that level of savings up. It then goes on to say if you had policy change, you could reduce that to 600 a year for the first 2 years, and then it might have been 60 in the third year. So it's comparing 3,000 staff over 3 years to 1,260 staff. If you look at the green, it gives a staffing level in between those two. So it doesn't seem to, the costings in the green don't seem to anticipate that first or that second idea that DHS had, which was automate aggressively and reduce the number of staff that you need.
I'm just trying to understand what you're saying. Were you under the impression, are you telling us, that the NPP wouldn't entail debt recovery from ATO information?
I don't know, Commissioner. It doesn't go into that level of detail. I'm just trying to put together the and this is reading it now, put together the information provided in the executive memorandum and linking that to the MPP and then the green.
All right. Well, it sounds like a hypothetical exercise which you're not basing on any belief about the NPP, is that right, that you had?
No, I don't recall the MPP. This is just all based on plain reading of the three documents.
And so your theory is that perhaps somebody could have read the NPP and thought that it did not involve automated debt recovery.
Looking at the NPP, I'm not sure how you come to view that
Well, if you were the
automated debt
minister, for
recovery
example,
was
that you might
envisaged.
think that you were putting something through that didn't involve debt recovery on a large scale, which might involve averaging, for example.
Reading the NPP, I don't see how, with the information that's provided in the NPP, you'd be able to come to that view.
Okay.
Just for completeness on your last answer, Mr. Wann, if on the document on the left side of the screen, it could be taken to page 10 of 17, that is 3 pages earlier, and if in respect of the document on the right of the screen, it could be taken to page 3 of 6. Thank you. There was perhaps a little bit less than a fortnight between these two documents, the one on the left being signed on the 20th of February and the one on the right being received by you on 3 March 2015. In paragraph 7, you'll see the proposal in the first dot point is said to be a new approach to reconciling information with the ATO. And you'll see in the draft NPP on the right side, the second sub-dot point identifies that it remains a new approach, at least at that point of the description.
Those two words are the same?
Yes. And the second dot point in paragraph 7 on the left, on the executive minute, refers to the number of 866,857 customers for the 2010 to 2013 financial year with likely incorrect payments.
That's correct.
And you see that that same figure appears in the 5th dot point on the same document, although it's described as 857,000 interventions for customers. And if you compare that to the second dot point on the right-hand side, you'll see that the department's referring to the significant clean-up of potential incorrect payments for 857,000 customers for the same financial years. You can see that?
Yep, that's correct.
How could you rationally conclude from the draft NPP that the ability to achieve the same number of interventions or the same number of customer reviews for the same period of time could be done other than in circumstances which was described in the executive minute, which required legislative change?
Through a combination of increasing the level of staffing that was envisaged in the more aggressive option that was put forward by DSS to more closely align to what they would have required if they were to use the existing arrangements. And secondly, I suspect the provision of information to clients to tell them what their income was and give them an opportunity to rectify. So it seems to have been a two-pronged approach. Now, I'm not making any value judgments as to whether that's realistic or not. I'm just saying that an MPP doesn't come to a minister, final MPP doesn't come to a minister without a settled position. And it seems to me that what was in the MPP is not exactly as described in 7. Yes, you are referring to a couple of words that are the same in terms of a new approach, and yes, you are referring to the same number of people, but the details around it are quite different, it seems to me.
What details are different, do you say?
Well, apart from the two that I've mentioned in terms of the number of staff that would have been required, and the closeness in the language or the consistency in concepts between those second lot of paragraphs I referred to in attachment B and the first dot point in the MPP. It goes on to say in the MPP, in the executive minutes under option 7, third dot point, it goes, the customer will have an opportunity to update the information prior to being applied to the Centrelink record. There's no reference, for example, I don't think, to it being put on the record.
Probably the first sub-dot point, which says the information would be presented to the customer via the online account and require them to either confirm the information is correct or provide updated information. This puts the obligation onto the customer to ensure their record is correct and will remove the significant regulatory burden for small businesses.
But it doesn't go on to say that it would put that on the record, on the Centrelink record, being applied to their Centrelink record.
Sorry, I'm not following.
The language that they use in these submissions, I mean...
The executive minute?
In the executive minutes and MPPs, they often use very precise language, and I suspect that the lack of reference to it being applied, the results of that update being applied to the Centrelink record being in one, the executive minute, and not being in the other, is an important omission. The other, obviously, the biggest difference, though, the biggest difference is the very clear statement that this will not change how income is assessed or overpayments calculated. And the other very big difference is that the numbers of staff required in the MPP is greater than was envisaged in the more aggressive option that was being put forward in the executive minute.
Okay, I'm not sure the executive minute referred to the numbers of staff, but if it's there, it'll be there.
Yeah.
But did you not read the executive minute as referring to a change in approach because of the way in which the ATO data was used, not whether it was highly automated, not whether it was automated or required lots of hands on deck to do it. It was the change in the way in which the ATO data was used, which was the point which attracted policy and legislative change questions.
In the executive minute, it is putting forward a more aggressive option. I'm not disputing that under option 7. I'm just saying that the MPP and the subsequent green don't align well with that option.
And to be clear, this is the process of analysis you've undertaken, which starts from the premise that an NPP is not provided to a minister until there's a settled position.
Between the primary department and the yes, portfolio agency. That's correct.
I'm intrigued by your level of preparation, Mr. Wann. Did you get out the finance screen and the executive minute and the NPP and study them up for today's purposes?
In preparing my statements, yes, sorry.
Commissioner.
Yes, Commissioner.
The word you're looking for. And cross-referenced and arrived at this explanation?
Yes, just reading the 3 documents.
Thank you.
From your preparation, are you able to identify the first point in time at which Minister Morrison was provided with the settled position as you've described it?
My recollection of no, sorry. I actually don't recall the MPP at all. My first, after examining my emails though, it became clear that the first engagement that I had, and then likely that the Minister had, would have been when the MPP was provided to me on the 3rd of March.
Well, that's certainly the earliest that it could have happened. But have you identified that DSS had any input into it at that stage?
No.
Does that suggest to you that it might have been a DHS position reflected in the minute rather than a settled position as you've described it today?
For DHS to get the minute through to the Senior Minister without going to the policy agency, the lead agency, would be highly unusual.
Yes, thank you, Commissioner. I didn't have any further questions.
Ms Hogan-Doran, anything from you? Mr Adjutidis?
If I could have leave for a couple of quick questions.
Yes, of course.
Thank you. You recall the exchange you had with the Commissioner and with Council assisting about the comparison you were doing between the executive minute and the draft NPP, and I'll shorthand it. You acknowledged in answer to some questions that it was an exercise you were doing for today's purposes. It was a hypothetical analysis you were doing. You remember all of that?
Yes.
Is that an analysis that you undertook back in 2015?
No.
And was it part of your role back in 2015 when these documents were created, and that you may or may not have seen them? Was that part of your role?
No.
Thank you. Nothing.
So why did you do it for today?
Because I looked at all the documents that related to this that were referenced that that would have worked through the Minister's office. I was, for part of the time, Senior Advisor looking after budget. So in all likelihood, all of these many MPPs would have crossed my desk. So I read the MPP as a result with the executive, with the Green saying I would have read that because I would have likely have seen it. And even though there's no evidence that I did see the executive minute, again, because of the role that I played, it was likely that I would have seen it. So in preparation for this, I read the documents.
Yeah, you read them, but why did you go through this exercise of working out how you might be able to rationalise this with that?
Because I wanted to understand the relationship between the three.
Well, why did it matter to your evidence?
I wanted to get across the brief.
You wanted, sorry, to get across?
To get across the brief. I wanted to understand what was happening.
But from what you're telling us, you wouldn't understand what was happening because you don't recall seeing any of these documents. All you've come up with is a
I did limit myself to those documents, that's right. But there's a clear, in terms of looking after the budget, there's always a preparatory work that occurred. In this case, because it's DHS, there was very limited visibility in our office, but the one bit of visibility would have been that executive minute. So that's the source that leads to the MPP, then that leads to the Green.
Okay, you're just not really clarifying for me why you were concerned to go through this exercise for today's purposes when you weren't even the Chief of Staff when the executive minute came in. And it's really neither here nor there, and at the end of the day, what your evidence or what you think about how it happened. Why did you go through that process?
Sorry, Commissioner,
Well, you seem to have done a fairly detailed comparison of the finance green brief, the NPP and the executive minute. And you did that for the purposes of today's hearing, and I'm struggling to understand why you felt that necessary.
Because I was responsible for the processes that these were part of. They were part of the evidence that I was looking at, and I wanted to understand it.
Okay, well, that would be fantastic if you had some contemporary understanding, but you don't, from what you tell us.
No,
Okay.
but I do have experience on how MPPs are developed
Yes.
and what to look for in them.
All right. Anything else you wanted to say on that?
No?
Okay. Mr. Andrea T. Oh, sorry, Ms. Hogan-Doran, you had something?
Commissioner, I had some questions that arose just out of the passage of it between the Witnesses' Council. You were asked some questions as to the analysis that you had done and whether that had been your role at the time in 2015. Do you recall that
Yes?
exchange? Was it anyone's role in 2015 in that office?
So each senior advisor and some of the junior advisors had areas of policy responsibility, and that was identified in structure charts. There was a senior advisor responsible for compliance and DHS. That's correct.
And do you recall now who undertook that role or had that allocation in 2015?
In reviewing the evidence, I saw it was Danielle Donegan.
Thank you, Commissioner.
Mr. Andrew Teddes?
Nothing further, thank you, Commissioner.
Okay. You had nothing arising out of that, did you, or did you?
Just two questions.
Okay. And I'll come back to you, Mr. Andrew Teddes, in case something comes out of this.
Did you anticipate a line of questioning about how it was justifiable not to inquire about the change of whether legislative change was required for the NPP, as had been indicated in the executive minute?
Sorry, can you repeat that?
In preparing for your evidence today, did you anticipate a line of questioning about why no one asked whether legislative change was required for the proposal as it was set out in the NPP in view of that indication in the executive minute?
I think it's a fairly obvious line of questioning, yes.
And did you talk to anyone about that who has given evidence here?
No,
Did you talk to Mr Morrison about the question?
absolutely not.
Have you had any communications with him at any point?
With
Mr Morrison?
absolutely not.
When was the last time you had any communication with him?
I remember it clearly. It was in 2019 when I was working in aged care.
Did you feel some sense of responsibility for the lack of any appearance of asking the question as you reviewed the documents, which led you to think, how could it be rationalised?
I was curious.
Curious about why no question had been asked.
Oh no, sorry, curious about how it might be, how it worked through. Sorry, I don't think I understood your question.
When you looked at the documents in preparation for your evidence, you say that there was a clear indication or a clear inference or an obvious question about why no one asked was legislative change required. That's right?
I think I'm being obtuse here.
You said you thought it was a fairly obvious line of questioning.
Oh yes, yes, yep,
That is your state of mind as you reviewed the documents, as I understand.
yes,
That's how it arose.
yes.
Put another way, it occurred to you on your review of the documents that the lack of asking the question or the absence of any evidence that the question was asked was obvious to you.
No, I wouldn't infer that.
Well, how did you think that it would be an obvious line of questioning if you didn't reach that view on the documents?
I was generally aware that that there was a view that there was a jump from legislation required to no legislation being required.
When did you have that awareness?
It may have been because I have viewed the evidence. I'm just trying to think, actually. It might be when I viewed the evidence given by Mr. Morrison and his package of documents that was provided to me by AGS.
When you say you viewed the evidence of Mr. Morrison, that is the day he gave evidence in this commission.
I've read his transcript, yes.
Did you view his evidence in a visual sense?
No.
Right. Thank you. Nothing further.
Mr Andrew-Tedis.
Nothing further, thank you.
Right, thank you. Do you want Mr Wann excused?
Yes, thank you.
Thanks, Mr Wann. You're excused. We'll adjourn till 10 a.m. tomorrow.
All rise.
10 o'clock.
Commission stands adjourned until 10 o'clock tomorrow morning.
Sort that for me.